for the opening of the hearings on the merit of the case and ask them to provide by the 8th of September 2025 the names of any witnesses and experts they intended to call during the oral proceedings, as well as other information required by Article 57 of the Rules of Court. The parties communicated to the registry within the time limit fixed information concerning the witnesses and experts that they intended to call at the hearings. The Gambia indicated that it wished to call witnesses and an expert, whereas Myanmar stated that it intended to call only witnesses. By letters dated the 17th of October 2025, the registrar informed the parties of decision taken by the court in relation to the hearing of the witnesses and expert during the oral proceedings. The parties were in particular informed that the court had decided that the parties' witnesses and expert to be called by the Gambia would be heard in the order requested by each party. The parties were required to submit by the 18th of November 2025 a written affidavit for each of the individuals they intended to call as a witness at the hearings. The Gambia was also required to submit a written statement by the expert it intended to call to testify. The parties were also requested to provide, by the same deadline of the 18th of November 2025, unredacted copies of any previous statements or accounts given by the witnesses or expert called to testify during the oral proceedings, which have been annexed to their pleadings in redacted form. The letters underscored that the unredacted version of the affidavits, written statement of the expert, and prior statements or accounts provided by each party would be communicated to the judges and the other party, but would be treated as confidential and would not be made public, available to the public. By letters dated the 13th of November 2025, the Deputy Registrar informed the parties of further decisions taken by the court concerning the procedure for examining the witnesses and the expert called by them. The parties were thus advised that after making the solemn declaration provided for in Article 64A of the Rules of Court, each witness would be asked to confirm his or her written affidavit, and if applicable, any prior written statements or accounts annexed to the written pleadings, subject to any correction the witness may wish to make. The calling party would then proceed to its direct examination, which would take the form of replies by the relevant witness to questions put to him or her by counsel. This would be followed by cross-examination of the witness by the other party, which would be confined in scope to written and oral statements already made as part of the witness evidence in chief. A re-examination by the calling party would then be possible, limited to matters having arisen as part of the cross-examination. The expert called by the Gambia would be asked, after making the appropriate declaration in accordance with Article 64B of the Rules of Court, to endorse his written statement as well as his earlier reports annexed to the Gambia's written pleadings, subject to any correction the expert may wish to make. The written statement and reports would constitute the expert's evidence in chief and serve in lieu of his direct examination at the hearings. This would be followed by cross-examination of the expert by Myanmar, which would be confined in scope to statements already made by him as part of his written statement or reports, and re-examination by the Gambia, which would in turn be confined to matters arising as part of the cross-examination. Following re-examination, question could be put to the relevant witness or expert by the President on behalf of the court or by individual judges. The witnesses and expert would respond orally and without delay to any question put by the parties or by the judges, except in particular circumstances, for example, when specific information was requested that needed to be verified. In order to ensure the safety of the witnesses called by the parties, the court decided that they would be heard in closed sessions, with only judges, registry staff, interpreters, technical personnel, and members of the delegation on the official list provided by each party to the court being allowed in the courtroom during the in-camera sessions. The parties were also informed that the court had agreed to the use of pseudonyms when addressing the witnesses called by the parties or when referring to them at the hearings. By a letter dated the 18th of November 2025, the Gambia provided written affidavits of its witnesses as well as the written statement of its expert. By a letter of the same day, Myanmar informed the court that it intended to call only one witness and reserved the right to call a different witness if for any reason the former should be unavailable to testify. Myanmar also provided confidential written affidavits for both of these witnesses in the Myanmar language, accompanied by certified translations into English. It further indicated the pseudonyms that should be used for these two witnesses. After ascertaining the views of the parties, the court decided, pursuant to Article 53, Paragraph 2 of its rules, that copies of the pleadings and documents annexed in their redacted versions as appropriate will be made accessible to the public on the opening of the oral proceedings, except for certain annexes that would be kept confidential. In addition, with regard to written pleadings and documents annexed, which contain written statements and accounts given by the witness called by the parties, as well as the redacted version of the affidavit of witnesses and the verbatim record of their testimonies, it was decided that these materials would only be posted on the court website after the end of the oral proceedings. The court also decided to make accessible to the public, on the opening of the oral proceedings, the reports submitted by Myanmar on the measures taken pursuant to subparagraph 4 of the operative clause of the Order on Provisional Measures of the 23rd of January 2020, and the Gambia's comments on them. In this respect, the court notes that the parties were consulted on this matter and did not object to such publication. Further, after consulting the parties and the intervening states, the court decided to make accessible to the public, on the opening of the oral proceedings, the written observations of the parties on the declarations of intervention pursuant to Article 83, Paragraph 1 of the Rules of Court, the written observations of the states seeking to intervene and those of the parties on the admissibility of the declaration of intervention in accordance with Article 84, paragraph 2 of the Rules of Court, as well as the written observations of the intervening states referred to in Article 86, paragraph 1 of the Rules of Court on the subject matter of their intervention. I note the presence in the court of the agents and counsel of the two parties. In accordance with the arrangement for the organization of the proceedings which have been decided by the court, the hearings will comprise a first and second round of oral argument. The first round will begin today with the oral pleadings of the Gambia and will close on Tuesday, the 20th of January 2026, following Myanmar's first round of pleadings. For the first round, each party will have 6 sessions of 3 hours at its disposal. The second round of oral argument will begin on Monday, the 26th of January, and conclude on Thursday, the 29th of January. Each party will have 3 sessions of 3 hours to present its reply. In addition, the court will hear witnesses and experts between the 2 rounds of oral argument. The witnesses of the Gambia will be heard in 3 closed sessions on the morning and afternoon of Wednesday, the 21st of January, and on the morning of Thursday, the 22nd of January. The expert called by the Gambia will be heard in open session on Thursday, the 22nd of January at 3 p.m. The witness called by Myanmar will be heard in closed session on the morning of Friday, the 23rd of January, 2026. In this first setting, the Gambia may, if required, avail itself of a short extension of time in view of the time taken up by my introductory words. I now give the floor to the agent of the Gambia, High Excellency Mr. Dawda Jallow. Sir, you have the floor.
Mr. President, esteemed judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. 6 years ago, the Gambia filed its application with this court, seeking to hold Myanmar accountable for its violations of the Genocide Convention. In January 2020, you ordered provisional measures and did so unanimously. We are now finally in the merits hearing, after which the court will decide whether Myanmar is responsible for acts of genocide against the Rohingya group, as alleged by the Gambia. As you will hear over the next 3 weeks, and in particular over the next 4 days, in deciding to bring this case, the Gambia acted on the basis of most careful reflection and assessment of the facts. We did not bring this case lightly. We brought this case after reviewing credible reports of the most brutal and vicious violations imaginable inflicted upon a vulnerable group that had been dehumanized and persecuted for many years. We received and carefully examined the meticulous reports of the United Nations fact-finding mission, dispatched by the UN Human Rights Council. We also examined reports issued by the reputable international human rights organizations, which sounded the alarm on the genocide of the Rohingya unfolding in northern Rakhine State. Those credible reports from diverse and independent sources left no doubt in our minds that Myanmar had to be held accountable for its violations of the Genocide Convention. And so we acted. Genocide Convention is the first multilateral human rights treaty that have been adopted. But its words will be meaningless unless they are acted upon and enforced. It is up to the state parties to the Genocide Convention to invoke affirmatively its provisions in order to truly liberate mankind from the odious scourge that is the crime of genocide. That is why the Gambia invoked Article 9 of the Convention and brought its dispute with Myanmar to this honorable court. The Gambia stands tall in the international community of states and takes pride in promoting and protecting human rights, including international accountability for genocide and other atrocity crimes. We do this out of sense of responsibility, grounded in the history of which we too suffered under a military junta. Over 2 decades of brutal dictatorship have taught us that we must use our moral voice in condemnation of oppression, of crimes against individuals and of groups, wherever and whenever they occur. It is also taught to us that accountability is imperative. Otherwise, impunity will ensure that such crimes are repeated over and over. In present times, these issues are more important than ever. And the court's role is more important than ever as a bastion for the rule of law. Sadly, Myanmar appears to be trapped in a cycle of atrocities and impunities. Nobody has been held responsible for the crimes against the Rohingya. Indeed, the military that perpetrated the genocide actually felt emboldened to overthrow the civilian authorities again. Myanmar's original agent in this case, the former state councillor, Madam Aung San Suu Kyi, has been imprisoned by the military junta, deprived of her liberty since she was swept from power by the same generals who continued to rule the country. And Senior General Min Aung, who commanded the military during the genocide, now rules over Myanmar as the leader of the junta. Predictably, violence and atrocities have spread throughout the country, affecting Myanmar nationals of all ethnic groups. Mr. President, while Gambia is the only applicant state, we are not alone in this cause for justice and accountability. Indeed, as the General Assembly stated in 1946, genocide shocks the conscience of mankind and results in great losses to humanity. And this is because humanity, our shared humanity, is made of various groups protected under the Convention. This is why we stand before you with full backing and support of 57 member organizations of Islamic cooperation. We also stand in solidarity with 11 intervening states from across the world who have urged the court to interpret the Convention in a meaningful way in the manner advanced by the Gambia. We stand too with the support of dozens of international human rights organizations and defenders whose investigations and reports have corroborated the findings of the UN fact-finding mission and its successor, the International Investigative Mechanism for Myanmar. And most importantly, we stand together with and for the Rohingya survivors of Myanmar genocide. This group of Myanmar nationals have endured decades of appalling persecution and years of dehumanizing propaganda. This culminated in the savage genocidal clearance operations of 2016 and 2017, which were followed by continued genocidal policies meant to erase their existence in Myanmar. We are proud that, once again, Gambia's delegation includes several members of the Rohingya community, including those who have traveled from the refugee camps in Bangladesh to be with us at this hearing. I invite them to stand so their presence may be acknowledged. Thank you. I turn to the case. It is not about esoteric issues of international law. It is about real people, real stories, and real group of human beings, the Rohingya of Myanmar. They have been targeted for destruction. They are farmers, laborers, teachers, mothers, fathers, sons, daughters, grandparents. They are ordinary folk. They have dreams and aspirations like all of us. And first and foremost, it is the most simple dream to be able to live in peace in their homeland under conditions of dignity and security. Myanmar has denied them that dream. In fact, it turned their lives into a nightmare, subjecting them to the most horrific violence and destruction one could imagine. 3 of the Gambia's witnesses, who will testify in closed sessions next week, have to endure that nightmare personally. They are first-hand eyewitnesses to the clearance operations that took place in 3 of the villages that were focused on by the UN fact-finding mission, namely Minji, also known as Tulatoli, Chutpin, and Muanu, also known as Monapara. All 3 of them lost family members in genocide. For their safety, we will only refer to their initials when we reference their written and oral testimony in these oral proceedings. Mr. President, members of the court, the Gambia has carefully examined jurisprudence and has fit this court's jurisprudence and has fit its case within that legal framework. There were genocide acts and there was genocidal intent. During the clearance operations in 2016 and 2017 and subsequently. This is evident based on particular circumstances in many villages and Myanmar's overall pattern of conduct. The Gambia believes that the evidence that has been submitted to you and which you will hear described this week admits of only one reasonable inference in regards to that pattern of conduct, that Myanmar acted with intention to destroy the Rohingya as a group or in whole or in part. The Gambia is proud to be represented by a diverse and talented team of international advocates who will present all aspects of the Gambia's case. 5 of them, including 2 Gambian state attorneys from my chambers, will be pleading before this court for the first time. After me, Professor Philip Sands will introduce the legal context for this dispute. He will be followed by Paul Reigler, who will provide an overview of the Gambia's case in the context of the court's previous 2 genocide cases, and that is Bosnia, Serbia, and Croatia, Serbia. Mr. Aslan Suleiman will then provide an overview of the relevant geography, demography, and history of the Rakhine State and discuss why the Rohingya are a protected group under the convention. In the afternoon, Mr. Reigler will return. In the afternoon, Mr. Reigler will return to discuss the quality and reliability of Gambia's evidence in this case. Then Mrs. Tafagwa Pasipanudia will present the history of discriminatory laws and persecution of the Rohingya in Myanmar, which is one of the indicators of Myanmar's genocidal intent. Mr. Suleiman will return to discuss another of such indicators, Myanmar's year-long efforts to disseminate anti-Rohingya hate propaganda. On Tuesday afternoon, Mr. Andrew Lowenstein will provide an overview of Myanmar's anti-Rohingya clearance operations and discuss how their organized nature and execution constitute another indicator of Myanmar's genocidal intent. Our presentations will continue with 4 speakers who will provide detailed presentation on the clearance operations in specific locations. Ms. Pasipanodia will discuss Myanmar's genocidal attack in Minchi or Tulatoli. Ms. Jem Hong Ho will present on Myanmar's genocidal attacks in Chut Pien. Ms. Maria Mangom will examine Myanmar's genocidal operations in Muang Nu or Monu Port Para. And Mr. Charles Kombenjai will describe Myanmar's genocidal attacks in other notable villages. On Wednesday morning, Ms. Ho will discuss how the extreme brutality of Myanmar's clearance operations evidence Myanmar's genocidal intent. Ms. Pasiponodia will then focus on why the pervasive sexual violence during Myanmar's clearance operations indicates its genocidal intent. She will be followed by Mr. Lowenstein, who will demonstrate that Myanmar's targeting of children is also an indicator of its genocidal intent. After that, Ms. Yasmin Alamin will demonstrate that Myanmar's destruction of evidence is also an indicator of its genocidal intent. And Professor Per Dazin will conclude the morning session with a presentation on Myanmar's pervasive impunity and how that also reveals its genocidal intent. On Wednesday afternoon, Mr. Suleiman will show that Myanmar's argument that its clearance operations were ARSA counterterrorism operations is not a defense to genocide because the evidence fully established that the manner in which these operations were organized and executed contradicts every tenet of counterterrorism doctrine, including Myanmar's own. Mr. Lowenstein will then demonstrate how the evidence described by the previous speakers Mr. Lowenstein will then demonstrate how the evidence described by the previous speakers demonstrates Myanmar's commission of the actus reus of genocide under Article 2 of the Convention. He will be followed by Professor Sands, who will highlight proof that Myanmar acted with the requisite mens rea or dolus specialis of genocide, and that's its intent to destroy the Rohingya as a group, in whole or in part, is a manifestly reasonable inference to be drawn from that proof. Ms. Reichler will conclude our presentation on Wednesday by showing that genocidal intent is the only reasonable inference that can be drawn from Myanmar's pattern of conduct across the clearance operations, and specifically that the evidence demonstrates that it would be entirely unreasonable to infer that the intent of Myanmar's targeting, mass killing, maiming, raping of many thousands of unarmed and defenseless Rohingya civilians, including pregnant women, children, the elderly, and the infirm, as well as burning of their houses and razing of their villages, was to combat terrorism. On Thursday, in our final session, Ms. Jessica Jones will discuss all the breaches of convention for which Myanmar is legally responsible. Mr. Suleiman will examine Myanmar's breaches of the court's provisional measures order of January 2020. Then Professor Dezan will present the remedies requested by the Gambia. And finally, Professor Sands will conclude our opening presentations on Myanmar's Commission of Genocide, on the witnesses you will hear, and on the significance of this case. The Gambia will present one additional witness, Professor Michael Newton, who will testify in open session next week. Professor Newton is a former military officer who specializes in the laws of war and counterterrorism operations. His testimony will demonstrate that Myanmar's clearance operations cannot be reasonably explained by the intention to counter terrorism. Rather, the only reasonable inference that can be drawn from its conduct is an intention to destroy the Rohingya group as such. Mr. President, honorable judges, these oral hearings come at a time in which the fundamental principles of international law, as enshrined in the UN Charter, are under stress and threat globally. Many have lost faith in the promise of international law. And many are looking at this case to see if the Genocide Convention is more than just words on paper. We are confident that this court, the principal judicial organ of the United Nations, will stand in the breach and uphold the rule of law, which epitomizes our collective conscience. As the guardian of our moral and legal compass under the Genocide Convention, we come to you because this court is the only hope for justice and accountability that the Rohingya and all people of Myanmar so greatly deserve. Mr. President, members of the court, I thank you for your courtesy and for your keen attention to this case and for allowing me to address you. With your permission, I would ask that you call Professor Sands to the stand. Thank you.
I thank His Excellency Mr. Daud Jallow. I now invite Professor Philip Sands to address the court. You have the floor, sir.
Mr. President, members of the court, it is an honour to appear before you on behalf of the Gambia in respect of this application under the 1948 Genocide Convention. The importance of this case in relation to the protection of the Rohingya community in Myanmar and more broadly, and the importance of the issues before you at a time when the international rule of law is under grave threat are plain. This morning, I'm going to address the beating heart of this case, the meaning and effect of the Genocide Convention. How the court approaches this will determine how the Gambia's application is decided. And as you well know, the Convention is of singular importance in the history of modern international law. Adopted in 1948, very largely as a result of the efforts of one man, Raphael Lemkin, it was the first modern human rights treaty to be adopted after the horrors of the Second World War. It is emblematic. It is emblematic of who we are, of who we wish to be, of how truth and law are to address matters of raw power. If the Convention is diminished, then we are diminished. And the values that were articulated in that extraordinary post-war moment are diminished. The protections provided by the 1948 Convention have been addressed by this court on several occasions. These previous judgments inform how it is to be applied in the case of the Rohingya, and my colleagues and I will draw on these sources, guided by the rulings of this court, as well as judgments in genocide cases before other international tribunals and increasingly before national courts in respect of the points that I make in this submission. Mr. President, it's to be emphasized from the outset that there are many aspects of the legal framework which are not in dispute between the parties. Myanmar and the Gambia agree on certain aspects and what the Convention says about them, but there are important areas of disagreement. And in respect of these areas of disagreement, the Gambia and all 11 of the intervening states speak with one voice on how the Convention is to be understood, consistent with the history, the context, the object and purpose of the Convention, as this court has interpreted and applied it. That united interpretation is, we say, important, for it highlights that where Myanmar's interpretation diverges, as it often does, it is a solitary expression of dissent. I'm going to proceed this morning as follows. First, I'm going to address the context and negotiating history of the Genocide Convention. Second, I'm going to identify key aspects of subsequent practice under the Convention, which elucidates the approach we invite the Court to take. Third, I'm going to set out the significant points of agreement between the parties and the interveners on key provisions of the Convention. Fourth, I'm going to address the key components of genocide, namely the relevant actus reus and mens rea. And fifth, and finally, I'm going to address other aspects of the legal framework to be addressed by my colleagues in due course over the next 4 days. Start with the context, the negotiation of the Convention. Mr. President, Raphael Lemkin invented the word genocide. He constructed that word out of the Latin and Greek words genus and side, to mean the killing of a group or of a people. And here you can see the word in his own writing on the screen, a document that may be found in the rare book and manuscript library at Columbia University in New York City. He chose the word genocide as the title for Chapter 9 of his book, Axis Rule, which was published in November 1944. I've taken the liberty of bringing a copy of the first edition of that book, my own copy, to court today. As you'll see, it is personally inscribed by Raphael Lemkin in the Nuremberg courtroom on the 4th of July 1946. This room today is in direct connection with courtroom 600 and the Palace of Justice. And I invite you, please, to read all of Chapter 9 of that book. It's not long. It's available online. As you read Lemkin's words, I suspect, like me, you may be struck by two things. First, the convergence of Lemkin's account of the indicators of genocide that he found in the 1930s and the 1940s with the evidence that is before you in this case. And second, that the approach taken by Raphael Lemkin is fully consistent with the approach taken by this court in its jurisprudence. As you will know, despite the crime being argued before them, the judges at Nuremberg failed to mention the word genocide at all in the 1946 judgment. And this is what prompted Raphael Lemkin to engage in efforts elsewhere, leading up to the first ever session of the United Nations General Assembly, and ultimately his efforts bore fruit in December 1948. You, the judges of this court, need no reminder of the horrors which preceded and precipitated the formulation and adoption of the Genocide Convention, and which led states parties, including so many of the countries which you are each from, to heed Lemkin's exhortation to bring an end to the odious scourge of genocide. It was an imperative task in 1948 as the crime of genocide took its place alongside war crimes and crimes against humanity. And to be clear, while international law treats these crimes as distinct, it does not establish a hierarchy among them. Sadly, the task of 1948 remains as imperative today as it did then. There's one aspect of the negotiating process to which I wish to draw the Court's attention. Myanmar suggests that its crimes against the Rohingya, and they are crimes, cannot be characterized as genocide. Why? Because simply too few Rohingya were subjected to abusive acts. The argument is fallacious, as we will show in the coming days. But in this respect, the negotiation process of the Convention is important, as with Raphael Lemkin's intentions, because it makes clear that the crime of genocide is not a numbers game. The negotiating process involved 3 drafts, and in reaching agreement on the 3rd and final draft, there the negotiators addressed the scale of destruction necessary to constitute the crime of genocide. The negotiating committee recognized that the Convention should include as instances of genocide such crimes as group massacres or individual executions on the grounds of race, nationality, or religion. France's delegate promoted this position, allowing that even a single death could constitute genocide. That is the approach enshrined in the Convention's wording, that there must be an intent to destroy the group in whole or in part. Of course, in this case, terribly, there is not just a single death. There are thousands of deaths and tens and hundreds of thousands of other genocidal acts, with upwards of 1 million human beings today in Cox's Bazar. Pause for a moment and reflect on that number. Over 1 million people. But let us not forget that the words "in part" were explained by Mr. Rafat, who served on Egypt's delegation, as being intended to achieve the aim of the French amendment. I turn to subsequent practice. This Court's first interpretation of the Genocide Convention came not long after its adoption, the famous 1951 advisory opinion. And there the Court recognized and underscored the Convention's purpose, a purely humanitarian and civilizing purpose. The high ideals which inspired the Convention, the Court said, provide, by virtue of the common will of the parties, the foundation and measure of all its provisions. And so it is today. That purpose and those ideals inform the way in which the Court interprets and applies the provisions of the Conventions in this case. The Court's jurisprudence on the Convention, in particular with the Bosnia and Croatia judgments of 2007 and 2015 respectively, is the lodestar on which the Gambia's application has been based. Other aids to interpretation, including the jurisprudence of the international criminal tribunals and national courts, and it is worth mentioning that in particular it is the courts of Germany that have in recent years played the leading role in relation to rulings, judgments of genocide perpetrated in northern Iraq and Syria, including against the Yazidi population, as well as the findings of international commissions which provide guidance on issues arising under the Convention, as the interveners have made clear. But it is the Court's own jurisprudence, your jurisprudence, that has played a central role in guiding the Gambia's approach. And we've fully relied on that jurisprudence in the decision of the Gambia to bring the case and in arguing the case in our written pleadings and in the course of these oral hearings. That approach of the Court informs the views of all the interveners and the Gambia in these proceedings. And both parties and all the interveners agree on the basic and foundational principle articulated with force by the court in the Bosnia judgment, that a state is prohibited from committing genocide and a state may be held internationally responsible for the crime of genocide. And we note and agree with the Democratic Republic of Congo's very helpful summary of certain additional significant points of agreement. The DRC's submissions include the following. First, that a situation of armed conflict does not preclude the crime of genocide. Second, the Convention does not require that a genocidal intent be the sole motive pursued by a respondent state or its agents, but it permits of multiple and overlapping motives. Third, a genocidal intent does not have to be expressly stated and may be established or inferred either from particular circumstances or a pattern of behaviour or conduct. And fourth, the requirement that a substantial part of the protected group is targeted does not refer to a purely quantitative criterion, but is to be interpreted in the light of quantitative, qualitative, and geographic factors. These are very important points of consensus on the basis of which we say the court can proceed. I turn now to the definition of genocide, the famous Article 2 of the 1948 Convention. This provides as follows. In the present Convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such. The 5 acts that follow in the text of Article 2 are A. Killing, B. Causing serious bodily or mental harm, C. Deliberately inflicting conditions of life calculated to bring about the group's physical destruction in whole or in part, D. Imposing measures intended to prevent births, and E. Forcibly transferring children to another group. Any one of these acts committed with the requisite intent is sufficient to constitute the act and the crime of genocide. And my colleagues will take you to evidence over the course of this week which will show many acts falling within the first 4 categories of Article 2 having been committed by Myanmar against the Rohingya group. In the counter-memorial, Myanmar argues that the number of victims is relevant to the determination of whether the actus reus of genocide has been committed. This is wrong. It makes this argument specifically in relation to the actus reus of killing under Article 2A, and Myanmar invites the court to conclude that unless killings are, and I quote, part of a campaign committed on a scale that is capable of bringing about the physical destruction of the relevant group or part of the group, they will be inadequate to constitute the actus reus of the crime of deliberate destruction of a human group. You can read that at paragraph 4.61 of the counter-memorial. Pure invention. There is no basis in the text of the Convention or the jurisprudence of the Court, or as I've already explained, in the negotiating history of the Convention to support this erroneous claim in respect of the actus reus under Article 2A. To the extent that numbers may ever be relevant, it's a factor that goes not to actus reus, but potentially to the question of whether the mens rea of genocide has been made out. This is because it may, not necessarily, it may bear on whether there is a reasonable inference that acts were carried out with the specific intent to destroy the group. That aspect of establishing the existence of the mens rea of genocide is a point to which I will return on Wednesday to be followed by Mr. Reichler. But to be clear, there is no numeric or substantiality threshold inherent in the actus reus. As this court has observed, and the chapeau of Article 2 makes plain, there are, and I quote, two constituent elements, end of quote, to genocide, mens rea and the actus reus. And whilst both must coexist for genocide to have been committed, they are, and I quote your words, analytically distinct, end of quote. The issue of numbers or the existence of concerted plans plays no part in establishing actus reus. And I also wish to underscore that killings under Article 2A are only one of 5 possible genocidal acts, 4 of which have plainly been established in the evidence that is before you. The Gambia does not contend that acts within the scope of Article 2E, that's to say forcibly transferring children out of the group, took place. But acts in all 4 other categories of Article 2 have been committed. And as the 6 joint interveners have underscored, and I quote, there is no hierarchy among the underlying acts of genocide, and the legal relevance of all acts targeting a protected group must be emphasized, end of quote. Thus, although terrible killings undoubtedly have occurred in this appalling case, it has to be underscored that the other modalities of the actus reus are just as central to the Gambia's case as acts of killing. Prominent in this case are acts falling within the scope of Article 2, paragraph B, causing serious bodily or mental harm to members of the group. The kinds of acts falling with this category are sadly diverse in this case. They include acts of sexual and gender-based violence, acts causing physical and psychological harm, and acts of forced displacement. And you're going to hear a lot more from this from the witnesses next week. I make 2 particular points in this regard. First, Myanmar's campaign against the Rohingya is appallingly characterized by widespread sexual and gender-based violence. As the joint interveners have submitted, and as the Gambia has also affirmed, the harm caused by such acts is by its very nature and effects almost universally serious. This has been recognized by this court in the Bosnia judgment, which endorsed the vital findings of the Rwanda tribunal in the Akayesu case. And that case made clear that the effect of rape and sexual violence are one of the worst ways of inflicting harm on the victim as he or she suffers both bodily and mental harm, end of quote. These are genocidal acts. They fall within the scope of Article 2, paragraph B, all the more so where, as in the present case, children are involved, a point that is made with force by the interveners. They may also constitute actus reus under Article 2C and 2D. Very frankly, the evidence you're going to hear about this week is dreadful, and it's going to be very tough to listen to some of it. But listen to it we all must, and draw the necessary conclusions from it. We say you must. Second, forced displacement, the permanent expulsion of a people from their homeland, is plainly capable of causing serious mental harm to members of the group, alongside any physical harm suffered in the course of their expulsion or which contributed to their fleeing their homes. In this case, it affects not only hundreds of thousands and upwards of 1 million human beings, but it's recognized, expulsion is recognized by the ICTY as capable of being a genocidal act. And let's be clear, expulsions do not have to result from the formal removal of people by bureaucratic state processes, or the use of Auschwitz-style cattle cars. Expulsion arises in this case after the ransacking of villages, the burning of houses, the constant threat of violence against all who remain. It is these acts that contribute to the forced displacement that forms the actus reus within Article 2, paragraph B. And as the International Residual Mechanism for Criminal Tribunals has made clear, forced displacements do not always require physical force. They can, and I quote, be met through the threat of force or coercion, such as that caused by fear of violence, duress, detention, psychological oppression, or abuse of power, or taking advantage of a coercive environment. It is the absence of genuine choice that makes the displacement unlawful. End of quote. And this is exactly what has happened in the present case, along with the use of physical force, causing grave harms to the Rohingya within the meaning of Article 2, paragraph B. Such displacements may also be genocidal actus reus within the terms of Article 2C, as the court recognised in the Bosnia case. This point has also been widely recognised by international criminal tribunals in genocide cases. For example, in the Ptolemyer case, the Yugoslav tribunal held that underlying acts of genocide may include, and I quote, methods of destruction that do not immediately kill members of the group, but ultimately seek their physical destruction by systematically expelling members of the group from their homes. End of quote. I turn now to the second constituent element of genocide, namely the mens rea. This is a subject that has received a lot of attention, and not just from lawyers. Writers, journalists, psychiatrists, psychoanalysts, psychologists have all turned their mind to the key point, the question of intent. Now, I note, before turning to the dolus specialis of genocide, that each of the underlying acts, actus reus acts, have their own mens rea, which must be present in the perpetrator when the act is done. As this court explained in the Bosnia judgment, and I quote, killing must be intentional, as must causing serious bodily or mental harm. Mental elements are made explicit in paragraphs C and D of Article 2 by the words deliberately and intended, quite apart from the implication of the words inflicting and imposing. The acts, in the words of the International Law Commission, are by their very nature conscious, intentional, or volitional acts. End of quote. And so, for the actus reus to be present, the relevant acts must have been committed with the requisite volitional mindset. In most cases, it's going to be straightforward to establish that an act is intentional, as we say it is in this case. But, alongside this aspect, and as an essential ingredient in genocide, is the existence of what has been called a dolus specialis. The intent must be to destroy in whole or in part a national, ethnical, racial or religious group, and to do so as such. Now let's turn first to the first part of this totemic chapeau, the fundamental basis of genocide, the core feature of the crime, what distinguishes it from other crimes, is that it is predicated on establishing an intention to destroy. The intention, however it is expressed, must be to achieve the physical or biological destruction of the group in whole or in part. Although the extent to which such destruction is in fact achieved is not relevant to the establishment of the dolus specialis. The victim of a genocide must be part of a recognizable and definable group, joined by a common nationality or ethnicity or race or religion. The intent must be to destroy the group as such. That requirement was explained by this court in the Bosnia judgment, some of you will know very well, as underscoring that genocide requires an intent to destroy people who share a particular group identity because of who those people are, as the court said. The words as such emphasize that intent to destroy the protected group. In this regard, they are targeted not because of what they have actually done or might do, but simply because of who they are. That is what counts in genocide. And let's be clear, there's not a shred of doubt, none, that the Rohingya are a group within the meaning of the Convention, and there is not a shred of doubt that they have been and that they continue to be to this day targeted as such. My colleague, Mr. Suleiman, is going to address the point later today. Alongside these requirements, the chapeau to Article 2 stipulates that the intent has to be to destroy the group in whole or in part. As the court's findings in respect of Srebrenica make plain, a targeted part of a group has to be a substantial part. But that does not mean that it has to be a numerically significant part in the context of the group overall, where other factors combine to make it substantial. As the court stated at paragraph 296 of the Bosnia judgment, substantiality is to be assessed by reference to three elements, namely quantitative factors, relevant geographic factors, and emblematic or qualitative factors. The evidence you're going to hear over the course of this week and next will leave no doubt that the targeted part of the Rohingya group was by reference to these three elements, and it was substantial. I turn next to the need to establish the presence of the dolus specialis. As the court has made clear, this can be either on the basis of direct or indirect and circumstantial evidence. In the Croatia judgment 10 years ago, the court clarified its approach to identifying the existence of dolus specialis. It said, and I quote, "In the absence of a state plan expressing the intent to commit genocide, it is necessary in the court's view to clarify the process whereby such an intent may be inferred from the individual conduct of perpetrators of the acts contemplated in Article 2. In its 2007 judgment, the court held that, and you'll see the words here on the screen, the dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly demonstrated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent." End of quote. Now, those are words, no doubt, we're going to be coming back to. The court can proceed on the basis of overt, that is to say, written incriminating evidence of a general plan. But for understandable reasons, perpetrators have tended to avoid that approach. And so the court, very wisely, we say, has recognized, has affirmed, that it can proceed by reference to circumstantial evidence in two distinct situations. First, by reference to particular circumstances which are convincingly demonstrated, or second, by reference to a pattern of conduct which could only point to the existence of the special intent. In the context of this application, as the evidence on the court's record establishes and as will be addressed by my colleagues this week, there are particular circumstances which convincingly show that Myanmar and its state organs acted with genocidal intent against the Rohingya. And that is especially clear in the case of at least 3 individual villages: Minji, Chutpir, and Mangnu, the harrowing accounts of which will be presented to the court tomorrow morning. Just as in Srebrenica, in the Bosnia case, the particular circumstances of what happened in those 3 villages, the concerted violence and devastation, the disproportionate and utterly inhuman treatment of the Rohingya who lived there, the widespread sexual violence, and even the targeting of Rohingya children, present, we say, the inescapable conclusion that the crimes against the Rohingya who lived there were perpetrated with genocidal intent. To be clear, we say that those 3 villages also formed part of a pattern, a wider pattern of conduct, which extended to dozens of other locations in northern Rakhine state, and from which genocidal intent is the only inference that could reasonably be drawn from the acts in question. That does not mean, however, as I've already submitted, that in relation to a pattern of conduct, it has to be the only motive. What it means is that on the basis of the evidence before you as to that special intent, it would be unreasonable to conclude that an intent to destroy the group in whole or in part did not exist. And in this case, that test is plainly met. The pattern of conduct across the various locations identified in northern Rakhine is only explicable, we say, on a reasonable basis by the existence of a genocidal intent acted upon by Myanmar. When the court considers, as it must, all of the evidence taken together, the only reasonable conclusion to reach is that a genocidal intent permeated and informed Myanmar's myriad of state-led actions against the Rohingya. Now, we note that Myanmar, in its rejoinder, accepts and agrees that genocidal intent can operate alongside and simultaneous with other motives. The interveners also agree with that. Indeed, the court has itself recognized that certain acts performed without genocidal intent may nevertheless also assist in deducing the existence of a genocidal intent. For example, in the Croatia judgment, the court held that acts, and I quote, acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention and may be significant as indicative of the presence of a special intent inspiring those acts. End of quote. This makes it clear in our submission that both such intentions, ethnic cleansing and genocide, and maybe other crimes, may coexist. And in this regard, I refer you to the intervention of the Republic of Ireland and to Judge Bandari's helpful separate opinion in the Croatia case to explain the point. What this means is that for a pattern of conduct to point only to the existence of genocidal intent is not to say that it could point to such intent only. This is how Ireland has put it. And Ireland is, of course, a land of remarkable writers, thinking of James Joyce and Seamus Heaney and Colm Tóibín and Fintan O'Toole, writers who really know about the power of words. And their lawyers have done the same thing. This is how they put it. The human mind can, of course, accommodate and act upon more than one intention. And the same conduct could be intended to achieve 2 or more results, however attainable each may be. It follows that it is perfectly possible that a pattern of conduct upon examination could point to 2 separate intentions, only one of which is genocidal. This possibility was recognised by Judge Bandari in his second opinion in the Croatia case, were in warning against conflating punitive motive with genocidal intent. He noted that genocidal intent may exist simultaneously with other ulterior motives. This approach, which recognises and takes account of the realities and complexities of human behaviour, we might call it the human factor, and in particular its darkest acts of expression through violence and conflict, is messy and it's complex. But this approach has got to be the right one in the real world if the Convention is to have any practical utility or function. It is this precisely that informed Lemkin's approach, as you will see when you read chapter 9 of his book. He understood, writing in 1944, that the perpetrator's mind is often a concoction of messy, mixed, overlapping motives. And accommodating that human reality is a way in which the particular threshold imposed by the dolus specialis must reflect the actuality of how human beings are and why they act, individually and collectively through the state. What makes them, what makes us do terrible things to other people. While the Gambia recognises that it's the attributed attention of Myanmar that matters in this case, and not that of each individual perpetrator on the ground that has to be established, it also cannot be overlooked that a state acts through people. The court, in seeking to determine whether genocidal intent is the only reasonable inference to be drawn from a pattern of conduct, is not, therefore, asked to determine whether genocidal intent existed in isolation or exclusively or only. Rather, it is required to ask itself whether the evidence before it as to circumstances and conduct are such that, irrespective of the existence of any other motive or motives that may have been identified or stated, and which will no doubt be present in most real-world cases, a genocidal intent also must have been present. Myanmar's assertion that in the conduct of the clearance operations targeting Rohingya villages, it was merely undertaking counter-terrorism operations, cannot, therefore, serve of itself to rebut the existence of a genocidal intent. It is perfectly possible for there to have been a counter-terror motive behind some of Myanmar's actions, but at the same time, in the course of those operations, a genocidal intent also existed and prevailed, and in some form propelled the actions that were taken. Indeed, as Judge Cansare Trindade recognised in the Croatia case, and I quote, "Genocide may be a means for achieving military objectives just as readily as military conflict may be a means for instigating a genocidal plan." End of quote. In establishing whether genocidal intent must have been present in the context of a pattern of conduct, the court helpfully indicated in the Croatian judgment some of the most important indicators of that intent. And I'll mention four. They are, first, and I quote, "the scale and allegedly systematic nature of the attack," end of quote. Second, the fact that those attacks are said to have caused casualties and damage far in excess of what was justified by military necessity, end of quote. Third, quote, "the specific targeting of members of the protected group," end of quote. And fourth, quote, "the nature, extent and degree of the injuries caused to the protected population," end of quote. In this case, the UN fact-finding mission, an independent body, has a key role, and its findings, we say, are authoritative. It has identified 7 indicators of genocidal intent, not in abstracto, but in the vast amount of evidence it has gathered in respect of Myanmar's actions towards the Rohingya, and they strongly correlate with the factors the court identified that I've just mentioned in the Croatia judgment in relation to patterns of conduct. So the UN FFM, entrusted with functions by the United Nations, concluded that genocidal intent to destroy a Rohingya people as such could be inferred in the following way. First, the Tatmadaws' extreme brutality in its attacks on the Rohingya. Second, the organised nature of the Tatmadaws' destruction. Third, the enormity and nature of the sexual violence perpetrated against women and girls during the clearance operations. Fourth, the insulting, derogatory, racist and exclusionary utterances of Myanmar officials and others prior, during and after the clearance operations. Fifth, the existence of discriminatory plans and policies. Sixth, the government's tolerance for public rhetoric of hatred and contempt for the Rohingya. And seventh, the state's failure to investigate and prosecute gross violations of international human rights law and serious violations of international humanitarian law, both as they were occurring and after they occurred. In due course, my colleagues are going to take you through a close consideration of these 7 indicators which emerge from the vast amount of evidence before you. And the Gambia invites this court to reach exactly the same conclusions that the FFM did, namely that the only reasonable conclusion is that Myanmar acted in this case with genocidal intent. Of course, the commission of genocide is not the only internationally wrongful act prohibited by the Convention. Article 1 also creates an obligation to prevent and to punish genocide, and Article 3 prohibits a range of acts ancillary to genocide, including, but not limited to, conspiracy and direct and public incitement to commit genocide. Whilst the Gambia's primary case is that Myanmar has committed genocide in violation of Article 1 of the Convention, violations of Articles 3 and of the duties to prevent and punish genocide also form part of our case in full. And these other punishable acts will be addressed by my colleague, Ms. Jones, later in the week. Before I conclude, a brief word about the evidence before the court in this case, and you're going to hear more about this, and the approach that we invite the court to take. The court itself has set out its task in general terms, in other cases, plainly. It is the duty of the court, after having given careful consideration to all the evidence in the record, to assess its probative value, to determine which facts must be considered relevant, and to draw conclusions from them as appropriate. The court will make its own determinations of the facts on the basis of the totality of the evidence presented to it, and it will then apply the relevant rules of international law to those facts which it has found to be established. And so it's for the court to consider whether in totality the evidence before you, in the case brought by the Gambia, stands up. There's no single type of evidence or method of proof that the court restricts parties to rely on. Evidence from any source can be taken into account, and it will be for the court to assess its credibility, reliability, and probative value to the issues in question. It is for the party alleging a fact to demonstrate its existence. But even this, in the court's practice, is not an absolute rule. As the court has said, the determination of the burden of proof is in reality dependent on the subject matter and the nature of the dispute brought before the court. It varies according to the type of facts which is necessary to establish for the purposes of the decision of the case. So the court takes an inherently, and we say appropriately, flexible approach to the evidence it is prepared to receive and consider in order to ensure that it is equipped with the materials necessary to make its own determination of the facts and to apply to those facts the relevant rules of international law. Mr. Reichel is going to address this in detail. The Gambia's evidence, its reliability and its probative value will be a matter for him. Suffice it to say at this early stage, the totality, the body of evidence presented by the Gambia on this application, fully underpinned, as it is, by the careful, thorough investigations of the UN FFM and the many eyewitness accounts that were collected by that body, is compelling and persuasive. To take the words of the court, it is convincing. It provides a strong foundation for the court to reach conclusions on the facts and to find that the Rohingya genocide is clearly established. Mr. President, members of the court, I've addressed the existing legal standards for proving genocide under the 1948 Convention in general terms, including proof of dolus specialis. These standards build directly on the approach set forth by Raphael Lemkin in his book, Axis Rule. And so I'm going to conclude by returning to where I began. New conceptions require new terms, Lemkin wrote in November 1944. He noted in these pages the evolution of international law having brought about a considerable interest in national groups, as distinguished from states and individuals. He invented the concept of genocide to deal with that evolution. And by genocide, he wrote, we mean the destruction of a nation or of an ethnic group. This occurred, he continued, as a composite of different acts of persecution or destruction. And on his interpretation, they occurred in two phases. One, these are his words, destruction of the national pattern of the oppressed group. The other, the imposition of the national pattern of the oppressor. And he continued, the oppressed who were the subject of genocidal acts could remain or they could be removed. The oppressed were always members of certain national groups who lived as minorities. And I quote him, if these groups should not be adequately protected, such lack of protection would result in international disturbances, especially in the form of disorganized emigration of the persecuted who would look for refuge elsewhere. End of quote. And against this background of what he saw between 1933 and 1945, he proposed, quote, an international multilateral treaty should provide for the introduction of provisions protecting minority groups from oppression because of their nationhood, religion, or race. The 1948 Convention is that international multilateral treaty. And Lemkin's words, written in 1944, and Article 2 of the 1948 Convention capture, regrettably but exactly, what has happened to the Rohingya. Lemkin's assessment back in the 1940s was the product of a meticulous exercise of research and reflection. His book and the Convention are testament to the power of ideas, to their reduction into a written and legal form, and to their capacity to hope for the world as a better and safer place. Raphael Lemkin lived through terrible times, just as the Rohingya have. But at no point did he, or his colleague Hirsch Lauterpacht, or so many others like them, choose to curl up in a corner and weep, or conclude that action or international rules were pointless. And the Rohingya have adopted exactly the same approach. And so has the Gambia, whose Attorney General you heard from this morning. That is why the Gambia is here today. Mr. President, the Genocide Convention, including its Article 2, really matter. And so does its meaningful and effective interpretation and application on the facts of this case to the situation regarding the Rohingya. It's to that issue that Mr. Reichler will now turn, and perhaps after a brief pause, you would call him to the bar. I thank you for your attention.
I thank Professor Sands. Before I give the floor to the next speaker, the court will observe a break of 50 minutes. The hearing is suspended. Please be seated. The sitting is resumed. I now invite Mr. Paul Leichler to address the court. You have the floor, sir.
Mr. President, members of the court, it is, as always, an honor for me to appear before you. And it is a special privilege and a responsibility to appear on behalf of the Gambia in this historic case. We are very much aware of its significance for the parties, for the Rohingya people, for all parties to the 1948 Convention, including the 11 states that have intervened in these proceedings, and for the court itself. This imposes a particular obligation on counsel to be as careful as possible in dealing with the law and the facts, accurately and objectively, and to be as helpful as possible to the court in your effort to provide the right answers on the important issues that have been raised. These issues include, among others, the legal standards for proving genocide under the Convention, and the nature of the evidence upon which the court may confidently rest its determination of whether those standards have been met. Professor Sands has helpfully laid out our understanding of the existing legal standards for proving genocide, including proof of dolus specialis, as set out and applied by the court in its 2007 judgment in the Bosnia case and the 2015 judgment in the Croatia case. We understand that this is a relatively high standard of proof, and we feel that this is appropriate where allegations of genocide or other grievous international crimes are concerned. This does not mean that the standard set by the court has drawn universal praise. There has been a considerable amount of scholarly commentary about it, some of it critical. This isn't surprising. A few commentators, especially those who have seen the Peace Palace only in photographs, think they know better than you do what the law should be, and they relish telling you so. But that is not what the Gambia thinks. We respect scholarship, but we are not here as commentators. We are here to present our case under the law as your jurisprudence has established it. We do not question or challenge the legal standards you have set. On the contrary, we accept them and argue our case on the basis of those standards as defined and applied by the court in its prior cases under the 1948 Convention. We have no doubt that the evidence we have submitted fully meets those high standards. So we have no need for, nor do we seek, a change in the approach the court has previously established, including, but not limited to, the legal standard for proving genocidal intent. I will explain why this is so by comparing the evidence of genocidal intent in this case with the evidence the court found sufficient to establish genocidal intent in the Bosnia case, and then by comparing it with the evidence the court found insufficient in the Croatia case. Our central submission is that the evidence of genocide, including genocidal intent, in this case is much stronger and much more pervasive than it was in both of those cases. We say that the only reasonable inference that can be drawn from this evidence is that there was an intent by Myanmar to destroy the Rohingya Muslims as a group in whole or in part. My review of the evidence this morning will necessarily be introductory. The speech is intended as an overview of our case. This afternoon and for the 3 days that follow, you will hear a comprehensive presentation of it and how it satisfies the standards set by the court for proving both the actus reus and the dolus specialis of genocide by Myanmar. My intention now is to provide a roadmap that assists you in fully appreciating our presentation and in understanding how each of our speeches, as it is delivered, builds to the inevitable conclusion that Myanmar is responsible for the commission of genocide against the Rohingya Muslim group. With these opening remarks, I turn to the Bosnia and Croatia cases. As we all know, the Bosnia case is the only one in which the court found that genocide was committed. The court found it at one specific location, Srebrenica. The evidence showed that Srebrenica was predominantly inhabited by Bosnian Muslims. After it was taken over by Bosnian Serb forces, those forces separated approximately 7,000 Muslim men from the general population, removed them to a secluded area, and murdered them. As the court explained, quoting from the ICTY's trial chamber in the Krstić case, the perpetrators, quote, systematically targeted Bosnian Muslim men of military age, regardless of whether they were civilians or soldiers. Women, children, and the elderly were spared from death. They were forcibly displaced to other parts of Bosnia. Citing the appeal chamber in the Krstić case, the court found that the killing of such a large number of men, 1/5 of the overall Srebrenica community, quote, would inevitably result in the physical disappearance of the Bosnian Muslim population of Srebrenica. The court concluded on the basis of these facts that the actus reus of genocide under Article 2A and B of the Convention had taken place. The court found, further, that upon capturing Srebrenica and segregating the male population, quote, the Bosnian Serbs devised and implemented a plan to execute as many as possible of the military-aged Bosnian Muslim men in the enclave, and that this was sufficient to satisfy the dolus specialis requirement. The existence of this plan, which was not spelled out in any document, was considered proven by a number of factors identified by the court, namely, the number and nature of the forces involved, the standardized coded language used by the units in communicating information about the killings, the scale of the executions, and the commonality of the killing methods applied. Mr. President, it is our submission that if the court were to apply the same legal and evidentiary standards to the present case, it would have to conclude, as others have done, that Myanmar committed acts of genocide with genocidal intent against the Rohingya Muslim population during its so-called clearance operations in 2016 and 2017. In this case, unlike Bosnia, there were numerous Srebrenicas, that is, massacres of large numbers of Rohingya Muslims to destroy the group, based on their identity as such, carried out by Myanmar's armed forces in multiple locations across northern Rakhine State, where the vast majority of the Rohingya Muslims lived. In other words, what was proven to have occurred at a single site in Bosnia is proven here to have occurred in scores of different Rohingya villages in Myanmar. Many examples are given in our written pleadings, some of which will be discussed in detail by my colleagues. For now, I will call your attention to three of these. The first is Mingi, a village in Mongdaw Township. You can see its location on the map on your screens. Mingi had a population of approximately 4,300 Rohingya and 400 ethnic Rakhine. The UN fact-finding mission found that Mingi was, quote, the location of one of the largest and most egregious mass killings. Myanmar's armed forces, known as the Tatmadaw, commenced their so-called clearance operation in Mingi in the early morning on 30 August 2017. As reported by the UN fact-finding mission, as soon as soldiers entered the village, they, quote, opened fire and began burning houses. They shot directly at crowds of people fleeing to the riverbank or trying to swim across the river. Many of them were killed. Others, especially children and the elderly, drowned while trying to escape. Hundreds of Rohingya who did not manage to get away were trapped and, quote, rounded up on the riverbank. The Tatmadaw then separated the men and systematically executed them with rounds of bullets and killed those who had survived the shooting with large knives. According to the fact-finding mission, the Tatmadaw next, quote, turned to the women and children. Some of the children, continuing to quote, were shot, some thrown into the river, and others thrown onto a fire. An eyewitness recalled seeing around 27 children's bodies floating in the water afterwards. Tatmadaw soldiers then took dozens of women and girls to nearby houses. The fact-finding mission reported, upon arrival, each group was taken to a different room. Once in the room, women and girls were stripped and beaten with sticks, punched or stabbed. They were then raped in groups of up to 7 victims at a time. Many of the women and girls had infants and children with them who were killed or severely injured while their mothers were raped. The houses were then often locked and set on fire, and most victims who were still alive were burned to death. Mr. President, this went far beyond the horrors inflicted during the Srebrenica massacre where women, infants, children, and the elderly were not attacked. Satellite imagery analyzed by UNICEF confirms the determination by the fact-finding mission that the Rohingya houses and structures in Mingi were, quote, completely burned and destroyed. By contrast, the part of Mingi inhabited by ethnic Rakhine, a predominantly Buddhist ethnic group favored by Myanmar's military regime, quote, remains intact. Destruction of this Rohingya village and many others like it, after killing, grievously wounding, raping, and forcibly displacing the population, reflects even more than an intention to destroy the Rohingya as a population. It demonstrates an obsession with erasing them and their homes permanently from historical memory. The second example is Chatpin, the village in Rauthodong Township, shown on your screen now. The clearance operation there took place on 27 August 2017. According to the UN fact-finding mission, quote, hundreds of Tatmadaw soldiers surrounded the village, opened fire, shooting at villagers, including those who were fleeing, dragged people from their houses, shot them at point-blank range, or slit their throats with large knives. An elderly woman described to the fact-finding mission what occurred after she and her 70-year-old brother were pulled from their house. Soldiers used rifle butts to beat my brother on the head, and I saw his brains come out. I saw people being killed with long knives. The soldiers were also spraying bullets, and many people were injured and killed. Our village was full of dead bodies. I saw dozens of people killed. First, they shot the people, and then, if they were still alive and the body was moving, they used a machete to slaughter across the throat. The fact-finding mission found that the Tatmadaw, quote, set houses on fire, including those still occupied. Rohingya victims were, quote, forced inside houses before they were intentionally set alight. The fact-finding mission determined that the Tatmadaw, quote, specifically targeted children, including infants and babies. Quote, some were wrenched from their mother's arms and thrown to the ground. Others were thrown into fire and burned alive. Children and babies. In the aftermath of the assault on Chatpin, witnesses saw, quote, dead bodies everywhere, including those of children floating in the river. No less than 127 children under the age of 6 were slaughtered in Chatpin. As at Mingi, the UN mission found that women and girls were subjected to, quote, rape, gang rape, sexual mutilation, and sexual humiliation, including the mutilation of their breasts. UNICEF satellite imagery confirms the fact-finding mission's conclusion that, quote, the entire Rohingya village of Chatpin was destroyed, while in contrast, the nearby non-Rohingya village, quote, remains intact. The third example is Mongnu, a village in Buthadong Township. It's shown on your screen now. On the same day as the massacre at Chatpin, villagers awoke to the sight of several trucks full of soldiers arriving, with other troops advancing in small groups on foot. They surrounded the village and, quote, whoever ran was shot at. As reported by the UN fact-finding mission, the soldiers approached a compound of 2 large and interconnected houses where approximately 200 Rohingya had sought shelter and ordered the people to come out of the houses or else the buildings would be set on fire. Without waiting, they broke down a door in the main house and fired their weapons into it. Then they, quote, separated women and children from men and, quote, took the men out of the house and tied up their hands behind their backs. A soldier, identified by several witnesses as Sergeant Ba Kyo of the 564th Light Infantry Battalion, after speaking on the phone, told his detachment, quote, "We will kill them." The soldiers then, quote, opened fire on the men and boys and, quote, slit their throats with knives. Similar groups of men were taken to other places in Mongnu where they were shot or hacked to death. Again, as at Mingyi and Chutkin, the Tatmadaw took special aim at women and girls. Here, too, the UN mission found that many were, quote, gang raped, killed, and mutilated. Employing the same modus operandi as at the other 2 Rohingya villages just discussed, the Tatmadaw burned Mongnu to the ground in the days following the clearance operation. UNISAT analysis of satellite imagery confirms that around 320 structures were destroyed by fire in Mongnu and another nearby Rohingya village. These 3 villages are but a few examples. The evidence shows that Myanmar carried out clearance operations employing similar tactics and methods with the same extreme brutality and sexual violence and devastating effects in many other Rohingya villages in northern Rakhine State, with the gravest incidents having taken place, in addition to the 3 villages I have just discussed, in 4 other locations shown on this map. From north to south, they are Gudarpin, Indin, Khotan Kok, and Chain Karli. In total, the UN fact-finding mission reported that very similar mass atrocities against unarmed and defenseless Rohingya civilians were perpetrated by the Tatmadaw during these clearance operations in at least 54 separate locations. Clearance operations following the same modus operandi took place in numerous other Rohingya villages across northern Rakhine State. The mission verified through multiple interviews and other information clearance operations similar to those detailed above in a total of 54 separate locations, and it received first-hand accounts of additional clearance operations in a further 22 locations. The evidence shows that these were not random acts or the unintended consequences of undisciplined soldiers run amok. The timing and nature of the attacks make this clear. The Myanmar military units were not a group of Serb irregulars who suddenly formed an intention to destroy the Bosnian Muslims who had fallen into their hands after taking Srebrenica. Here, the evidence shows that the Tatmadaw units that deployed to scores of Rohingya villages in northern Rakhine State were following orders from a central military command which planned and directed that the clearance operations be carried out in all of these locations. As at Srebrenica, the genocidal intent of that plan is clearly identifiable from the particular circumstances of its execution. Unlike Srebrenica, Myanmar's plan was carefully and deliberately developed at the highest military level, not spontaneously by irregular forces on the scene. And it was executed across a large number of geographic locations, an even clearer reflection of Myanmar's genocidal intent. There is no doubt that Myanmar's soldiers were acting pursuant to orders emanating from the top of its military hierarchy. Myanmar does not dispute that the Tatmadaw operated under a highly centralized command structure removed from civilian oversight. At its apex was the Commander-in-Chief, Senior General Min Aung Hlaing, who directly commanded the Army, Navy, and Air Force. His authority also extended to all of Myanmar's security forces, including the border police, border guards, and civilian militias. According to the UN fact-finding mission, quote, the Commander-in-Chief led the Tatmadaw General Staff, which was responsible for formulating the objectives and limits of military operations, the role and composition of the forces involved, the rules of engagement, and the necessary logistics. In Myanmar's armed forces, as in the militaries of other states, subordinate officers and units operate pursuant to direct orders from their superiors, deviation from which risks immediate sanction. As Senior General Hlaing himself emphasized, quote, discipline and obedience are the backbone of the Tatmadaw, and each and every serviceman must strictly follow rules and regulations, orders and instructions. Beyond the Tatmadaw's command structure and organization, the existence of a calculated plan, conceived and developed at the highest level, to carry out the clearance operations against the Rohingya Muslims is evidenced by the strikingly similar modus operandi with which these operations were executed all across northern Rakhine State. In dozens of locations, the UN fact-finding mission observed a remarkable similarity in the timing of operations, the sequence of events, the types of weapons used, the assistance received from other security forces or ethnic Rakhine, the coordination and division of roles between perpetrators, the types of violations, and the manner in which they were committed. The modus operandi of these attacks was recognizable and consistent throughout. This could not have occurred. This could not have occurred in the absence of significant levels of forethought and organization. On the basis of this evidence, the fact-finding mission found that there was a, quote, consistent pattern of conduct, which is, quote, only possible when all troops are acting under the effective control of a single unified command, and that their operations have been, quote, planned, ordered, and supervised at the level of the Commander-in-Chief. This is another aspect of our case that makes it much stronger than the Bosnia case. In that case, the court did not find a pattern of conduct from which an intent to commit genocide against a specific group could be inferred. The particular circumstances of the massacre at Srebrenica, which the court did deem sufficient to constitute genocide, were not found to have occurred at other locations in Bosnia. This gives rise to a situation here that was not present in Bosnia, whether in addition to the particular circumstances of the massacres at numerous Rohingya villages, an intent to destroy the Rohingya as a group can also be reasonably inferred from what the fact-finding mission called Myanmar's, quote, consistent pattern of conduct in at least 54 different locations. In addressing this issue, as Professor Sands recalled for you, the fact-finding mission identified 7 factors drawn from the court's jurisprudence and that of other international tribunals, which it regarded as indicators of genocidal intent. And it considered whether these factors were present in Myanmar's clearance operations against the Rohingya. It then found, based on its comprehensive investigation and voluminous evidence, that every one of these 7 boxes could be checked. First, the Tatmadaws' extreme brutality during its attack on the Rohingya. It is beyond dispute that the Tatmadaw conducted the clearance operations with extreme brutality. They killed, maimed, and tortured members of the Rohingya group indiscriminately in a manner that inflicted maximum harm. The atrocities encompassed, among others, large-scale burning of victims alive, often by confining them in homes that were then set ablaze, mutilation with knives, soaking victims in petrol and setting them on fire, and the stabbing, cutting, or fatal beating of infants and young children in the presence of their parents. As regards boys and men, their Srebrenica-style separation and execution was a common feature. Second, the organized nature of the Tatmadaws' destruction. As already noted, the evidence establishes incontrovertibly that the clearance operations were carried out in a highly organized manner, pursuant to a coordinated military plan developed by the Tatmadaws' High Command and approved by the Commander-in-Chief. The clearance operations were thus preceded by careful pre-planning and preparation, and then executed according to plan by similar means across scores of Rohingya villages in northern Rakhine State. Third, the enormity and nature of the sexual violence perpetrated against women and girls during the clearance operation. The UN fact-finding mission identified as a, quote, notable pattern the perpetration of, quote, mass gang rape involving multiple perpetrators and multiple victims in the same incident. Victims included children and pregnant women, and the Tatmadaw committed these atrocities with unspeakable depravity, often subjecting the victims to torture and mutilation before killing them. Fourth, the insulting, derogatory, racist, and exclusionary utterance of Myanmar officials and others prior to, during, and after the clearance operations. Myanmar has steadily propagated over decades a racist message that the Rohingya are an impure and subhuman race that originated elsewhere, came to the country illegally, and reproduced so rapidly like animals that they threatened to supplant the pure-blooded national races favored by the government. Myanmar's dehumanizing anti-Rohingya hate speech reached a crescendo during the clearance operations in August and September 2017, when Senior General Hwang, the commander-in-chief, spoke of the threat to Myanmar's other races posed by the Rohingyas' mere existence, and gave his assurances that the Tatmadaw would soon be solving the long-standing, quote, Bengali problem, which was until then a, quote, unfinished job. Similar derogatory and threatening racist messages about the Rohingya were disseminated on Facebook, which had widespread reach in Myanmar. The UN's Independent International Mechanism for Myanmar, IIMM, which succeeded the fact-finding mission and supplemented its work, determined that at least 43 Facebook pages were connected to the military and used by the Tatmadaw at the time of the clearance operations, quote, to increase animosity toward the group. Imbued with these messages, Tatmadaw soldiers showed no restraint in their efforts to complete what their commander-in-chief told them was an unfinished job. As one Tatmadaw officer declared, quote, if they're Bengali, they'll be killed. Others, also taking the cue from the commander-in-chief, declared that the hour had come to, quote, kill all the Bengalis and destroy their race so that, quote, none of them should be left alive. Fifth, the existence of discriminatory laws and policies. For years prior to the clearance operations, Myanmar adopted and enforced racist laws and policies that specifically targeted the Rohingya, stigmatized and isolated them, characterized them as mortal enemies of the Buddhist peoples of Rakhine State, and incited violence against them. These official measures included deprivation of nationality and citizenship, restrictions on marriage and childbirth, prohibitions on movement and employment, and confinement in internment camps and ghettos. The UN fact-finding mission found that these openly racist laws and policies, quote, adversely impacted every aspect of their life, including their access to food, livelihood, health, and education. Sixth, the government's tolerance for public rhetoric of hatred and contempt for the Rohingya. Myanmar's senior military and civilian leaders not only tolerated, but actively disseminated vicious hate speech, turning the Rohingya into objects to be feared and despised by other ethnic and religious groups, and inciting those groups to rise up against them. The chief actor was Senior General Hwang himself, who incited Myanmar's Buddhist races against the Rohingya by openly declaring that absolutely our country has no Rohingya race, and warning that, quote, the Bengali population had exploded to the point that it would, quote, swallow them up. And seventh, the state's failure to investigate and prosecute gross violations of international human rights law and serious violations of international humanitarian law, both as they were occurring and after they occurred. Despite the enormity of the crimes committed, Myanmar has been unwilling to properly investigate, let alone prosecute the perpetrators. Instead, it has steadfastly refused to cooperate with impartial international agencies, including from the United Nations, and it has invested heavily in destroying evidence, including by razing the remains of the Rohingya villages where the genocide occurred. True to its nature as a de facto military government, Myanmar has cloaked its armed forces in an impenetrable gown of impunity. After reviewing the evidence of Myanmar's conduct under these 7 headings, the UN fact-finding mission concluded in 2019. Every one of these indicators is linked to the acts or omissions of Myanmar state organs, including the military, other security forces, ministries, legislative bodies, the UEHRD, and other civilian institutions. Collectively, they demonstrate a pattern of conduct that infers genocidal intent on the part of the state to destroy the Rohingya in whole or in part as a group. For reasons explained in its 2018 report, there is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct. In sum, the evidence of genocide, including genocidal intent, is not only much stronger and much more pervasive in Myanmar than it was in Bosnia, but it was determined by the fact-finding mission to permit no reasonable conclusion other than genocide. Instead of a single Srebrenica, there were multiple villages where similar massacres of Rohingya Muslims took place. Instead of a renegade Serb militia whose actions the court was unable to attribute to a state, in Myanmar it was the state itself through its armed forces which perpetrated these atrocities. Instead of an impromptu intent formed immediately prior to the genocidal acts, in Myanmar there was a plan prepared well in advance of the clearance operations at the highest level of the armed forces and dutifully executed by subordinate officers and enlisted personnel throughout northern Rakhine State, employing the very same modus operandi. In Myanmar, in contrast to Bosnia, genocide, including genocidal intent, is proven not only by particular circumstances in particular locations, but also by a pattern of conduct demonstrating the existence of a plan, the intent of which it can only reasonably be inferred from its nature and the manner of its execution was to destroy the Rohingya as a group. Mr. President, the evidence before you also distinguishes the present case from the Croatia case. In Croatia, the court found neither particular circumstances, nothing equivalent to the massacre at Srebrenica, for example, nor a pattern of conduct from which genocidal intent was the only reasonable inference to be drawn. The case is nevertheless helpful to us here for several reasons. First, the court found that the actions of the respondent state constituted a pattern of conduct, evidenced by what it called, quote, similarities in terms of the modus operandi used between some of the attacks confirmed to have taken place, end of quote. These similarities included attacking and occupying Croat localities and creating what the court called, quote, a climate of fear and coercion by committing a number of acts that constitute the actus reus of genocide within the meaning of Article 2A and B of the Convention. Finally, the occupation would end with the forced expulsion of the Croat population from these localities, end of quote. By the same reasoning, the evidence in our case plainly establishes a pattern of conduct by Myanmar across the expansive geographic area in which the majority of Rohingya lived in northern Rakhine State. As you have seen, This was the conclusion reached by the UN fact-finding mission. Second, to determine whether genocidal intent could be reasonably inferred from the respondent state's pattern of conduct, the court considered factors that largely overlap those employed by the UN fact-finding mission in our case, and which the mission concluded were indisputably present in our case. According to the court, the most important factors in revealing a genocidal intent were, as Professor Sands recalled earlier, 1, the scale and alleged systematic nature of the attacks. Check. 2, the attacks are said to have caused casualties and damage far in excess of what was justified by military necessity. Check. 3, the specific targeting of Croats, in this case, the targeting of Rohingya Muslims. Check. 4, the nature, extent, and degree of the injuries caused to the Croat population. Again, substitute Rohingya Muslim for Croat and check. The court did not find that all of these factors were present in Croatia, but they are all undeniably present in our case. Third, and this is the feature that most distinguishes Croatia from our case, the court found that Serbia's policy was to establish an ethnically homogeneous Serb state, following the forced displacement of Croats from the parts of Croatia that Serbia hoped to annex, or at least control. The court found it determinative that this intention, quote, namely the forced displacement of the Croats, did not entail their physical destruction. It was not a question of systematically destroying that population, but of forcing it to leave the areas controlled by these armed forces. In other words, for the court, Croatia v. Serbia was a case of ethnic cleansing, but not genocide. To be sure, the one does not necessarily exclude the other. In the Bosnia case, the court explained that, quote, acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention, and may be significant as indicative of a specific intent, dolus specialis, inspiring those acts. However, in the Croatia case, the court did not consider that Serbia's ethnic cleansing of Croats was indicative of an intent to destroy them as a group. Its findings were to the contrary. It concluded that, quote, Croatia has not established that the only reasonable inference that can be drawn from the pattern of conduct it relied on was the intent to destroy, in whole or in part, the Croat group. This further distinguishes the Croatia case from our case. Myanmar's pattern of conduct, in contrast to that of Serbia, does not permit the court to reasonably infer that its intent was to forcibly displace or ethnically cleanse the Rohingya Muslim group. Myanmar itself does not claim that this was its intent, or that such an intent can be reasonably inferred from its conduct. In fact, Myanmar has consistently denied this. To be sure, Myanmar's clearance operations caused massive forced displacement, in addition to killing, maiming, and raping of the Rohingyas. As the court explained in Croatia, the existence of genocidal intent in such circumstances depends on whether, quote, the forced displacement was carried out in circumstances calculated to result in the total or partial destruction of the group. The evidence in our case shows plainly that it was, as the fact-finding mission concluded. As Professor Sands told you, Myanmar argues that the clearance operations were intended neither to forcibly displace, ethnically cleanse, or destroy the Rohingyas as a group. Its only defense of this conduct is to claim that its actions were intended to combat terrorism, specifically to counter the activities of the Arakan Rohingya Salvation Army, referred to by the acronym ARSA throughout the pleadings. The clearance operations were exercised in counterterrorism against ARSA, says Myanmar, not efforts to destroy the Rohingya as a group. This is, frankly, a hopeless argument that is entirely unsupported by the evidence. But in the circumstances, it appears to be the best defense that Myanmar can gin up. And we will give it due attention over the course of our presentation this week, including with a speech on Wednesday devoted entirely to this issue. For now, as a sort of preview, I will simply make 3 points about it. First, it is fundamental and should not be debatable that actual counterterrorism is based on ensuring the safety and security of the affected population and gaining its loyalty and support. This cannot be reconciled with sending the armed forces to scores of villages, setting fire to homes with families still inside them, shooting at everyone who moves, rounding up men and boys for mass execution, hacking children and infants to death, raping, gang raping, and mutilating women and girls before killing them, forcing survivors to run for their lives, and then razing their villages to prevent them from returning. This is what the evidence shows Myanmar did. And it is a description of genocide, not counterterrorism. Second, this is not a case, as Myanmar has argued in its written pleadings, of applying Western standards to a less developed country in the global South. Yes, our expert witness, Professor Michael Newton of Vanderbilt Law School, from whom you will hear next week, is a retired U.S. military officer. But he has devoted both his military and academic careers to the law of war and particularly to matters of counterterrorism, including in non-Western and developing states. His expert testimony is that the fundamental principles of counterterrorism strategy and tactics are nearly universally accepted, including most significantly by Myanmar itself. This is reflected in the Tatmadaws' own rules of engagement, which Myanmar has very helpfully attached to its pleadings. There is no problem with these rules, according to Professor Newton. The problem is, as you will be shown by my colleagues, that Tatmadaw completely ignored them in carrying out its clearance operations against the Rohingya. Most prominently, as the UN fact-finding mission concluded, the killing of civilians is inherently brutal in any context. The perpetrators of the clearance operations in Rakhine State introduced an additional dimension to this. There was not the least effort to make any spared. Mothers, infants, pregnant women, the old and infirm, all fell victim to the ruthless campaign. The targeting of women and girls for rape, gang rape, and other forms of sexual violence, as well as the targeting of and impact on children in general, has been shocking. The brutality with which the underlying acts were carried out provides further support for a conclusion that they were committed with genocidal intent. My third point is that the clearance operations were by several orders of magnitude far out of proportion to what was needed to defend against arson. This is how the UN's independent investigative mission for Myanmar described ARSA's capacity in August 2017 when Myanmar launched its clearance operations. Based on photographs and videos released by the Myanmar military, publicly circulated footage, witness testimonies, and official statements, the mechanism found that by August 2017, ARSA likely possessed a modest arsenal of 40 to 70 firearms of mixed types and calibers. Most ARSA members primarily used bladed weapons, sticks, and a limited number of artisanal firearms. While IEDs appear to have been used in the 2016 and 2017 attacks, there is no conclusive evidence that firearms were employed. It is not surprising that Myanmar would attempt to transform ARSA, armed mainly with knives and sticks, into a major fighting force and national security threat. To be sure, we do not suggest that Myanmar should have ignored ARSA. As a sovereign state, it had the right to defend itself against such an outfit, even if it was as poorly equipped as the evidence shows. However, history teaches us that when genocide occurs, it is almost always under cover of armed conflict. In this regard, it would be wise to recall the words of Judge Cansado Trindade in the Croatia case, partially quoted by Professor Sands. One cannot characterize a situation as one of armed conflict so as to discard genocide. The two do not exclude each other. In this connection, it has been pertinently warned that perpetrators of genocide will almost always allege that they were in an armed conflict and that their actions were taken pursuant to an ongoing military conflict. Yet, genocide may be a means for achieving military objectives, just as readily as military conflict may be a means for instigating a genocidal plan. Before concluding my presentation, I'd like to call attention to one more distinguishing feature from the present case and both the Bosnia and Croatia cases. In the prior cases, the court had the benefit of findings of fact by another international judicial body, namely the ICTY. To be sure, the court did not rely on those findings exclusively. In Bosnia, the court found helpful a report by the Secretary General on the fall of Srebrenica, describing it as having considerable authority because of the care taken in its preparation and the independence of those responsible for it. Likewise, in Croatia, the court found that it must give evidential weight to a report by the UN Special Rapporteur by reason both of the independent status of its author and of the fact that it was prepared at the request of organs of the United Nations for purposes of the exercise of their functions. Here, the centerpiece of our case has been from the very beginning the two voluminous reports consisting of more than 600 pages prepared by the UN fact-finding mission appointed by the Human Rights Council, which were published in 2018 and 2019. These too are notable for the care taken in their preparation and the independence of those involved. The evidence contained therein has been supplemented in the course of these proceedings by numerous equally independent and authoritative reports from the IIMM, other United Nations bodies, impartial non-governmental organizations, and various states, as well as 48 sworn statements from eyewitnesses, all consistent with the conclusions of the fact-finding mission, and all supportive of the Gambia's submission that Myanmar acted with genocidal intent in carrying out its clearance operations against the Rohingya in 2016 and 2017. Mr. President, members of the Court, I will speak again at the beginning of this afternoon session, delving further into the reliability of the sources of evidence on which the Gambia replies. And in the interest of time, I will simply conclude this presentation now by thanking you for your kind courtesy and patient attention, and asking that you call my good friend and esteemed colleague, Mr. Arsalan Suleiman, to the podium.
I thank Mr. Leichtler. I now give the floor to Mr. Arsalan Suleiman. You have the floor, sir.
Mr. President, members of the Court, it is an honor to appear before you again and to represent the Gambia in this significant case. This case is about Myanmar's acts of genocide against the Rohingya group. As I will explain, there can be no doubt that the Rohingya are a protected group within the meaning of Article 2 of the Genocide Convention. Myanmar's refusal to recognize them as such, or to even use the term Rohingya, is entirely without effect or relevance. I begin my presentation by providing an overview of the relevant geography, demography, and history of northern Rakhine State, the area where the Rohingya have mostly lived, or at least where they lived before Myanmar's genocidal clearance operations. I will then address the evidence that establishes the Rohingya to be an ethnical, religious, and/or racial group within the meaning of the Genocide Convention. On the screen is figure 1.1 from the Gambia's memorial. This is a map showing the location of Rakhine State outlined in red. This is the westernmost state of Myanmar with a coastline that runs along the Bay of Bengal. Zooming in, you can see more clearly that Sittwe, the capital of Rakhine State, is depicted on the map with a small circled black dot. Most of the acts of genocide during the so-called clearance operations that we focus on in this case occurred in the 3 townships northwest of Sittwe. Those townships, Buthidong, Mongdaw, and Rathidong, are depicted in figure 1.2 from the memorial, which you can see on your screens. Townships are an administrative unit of local governance in Myanmar. They are made up of towns and villages. The villages are grouped into village tracts. Numerous specific villages where clearance operations occurred are also depicted on this map. These townships are predominantly rural agrarian communities with populations spread out among hundreds of villages across these lands. The houses are mostly made of bamboo, with roofs made of palm leaves. There are no major urban population centers in this part of northern Rakhine State. The manner in which the Rohingya population was situated geographically in small villages rather than large urban centers is a key factor for the court's understanding of that part of the Rohingya group targeted by Myanmar's genocidal clearance operations. The total population of Rakhine State, as estimated by Myanmar's 2014 census, is 3.19 million. This includes people from many different ethnic groups, including Rakhine, Rohingya, Mro, Kaman, Dainet, Chin, and others. Around 1.1 million people out of that figure were, quote, unenumerated. This is because Myanmar reneged on its explicit commitment to allow the Rohingya to self-identify as such in that census. Those wishing to self-identify as Rohingya were not allowed to formally participate, but the 3.19 million figure includes that estimated unenumerated population. The population of Rohingya in all of Rakhine State, including in the state capital Sittwe, was estimated to be around 1.1 to 1.4 million pre-clearance operations. The largest Rohingya population centers were in the principal towns in Mongdo, Buthidong, and Rathidong townships. But in many of the villages, the populations were around a few hundred people. Over 700,000 Rohingya fled the clearance operations in 2017 and took refuge in Bangladesh. In terms of the Rohingya population, specifically in each of Buthidong, Mongdo, and Rathidong townships, those numbers are less certain. Before the clearance operations, the Rohingya made up around 80 to 90% of the population of these three townships, with Rakhine making up most of the rest of the population. According to data from Myanmar's 2014 census, Buthidong Township had a population of around 206,000 people, Mongdo some 112,000 people, and Rathidong around 140,000 people. It is unclear to what extent, if any at all, these figures include the unenumerated population. Mr. President, members of the court, for centuries, the Rohingya have called Rakhine State, or Arakan, their home. The Rohingya report, authored by Francis Wade for the Independent Investigative Mechanism for Myanmar, which we also refer to as the IIMM, notes that Muslims have been present in what is now Rakhine State since at least the 9th century, when Muslim seafarers set up trading posts along the coasts. There is additional compelling evidence that the Rohingya have lived in present-day Rakhine State for centuries and have called themselves Rohingya. A 1799 British colonial ethnography published by Dr. Francis Buchanan noted that, quote, the Mohammedans who have long settled in Arakan and who call themselves Rohingya, or natives of Arakan, end quote, speak their own dialect. An 1811 article in the British Classical Journal identified Rohingya as one of 3 languages spoken in the Burma Empire. The collection of languages published in 1815 by German professor J.S. Vader included an entry for Rohingya, noting the existence of the Rohingya ethnic group and its distinct language. Myanmar argues that there are no other similar historical sources that refer to the Rohingya as such. This fails to refute the fact that these specific sources did exactly that. At a minimum, these sources document the fact that the Rohingya referred to themselves as such, going all the way back to the end of the 18th century. Myanmar also argues that most of this population immigrated to Myanmar during the British colonial period, which began in the mid-19th century. While it may be the case that some populations moved into this region over time, the historical record makes clear that the Rohingya had been present as a group in this region for 3 centuries. The historical record also shows that after Burma's independence in 1948, its political and military leaders recognized the Rohingya as a distinct ethnic group. The first Prime Minister, U Nu, made the following statement in a 1954 radio address. Quote, "The people living in Mongdo and Buthodong regions are our nationals, our brethren. They are called Rohingyas. They are one of the same par in status of nationality with Kachin, Kya, Karen, Mon, Rakhine, and Shan. They are one of the ethnic races of Burma." End quote. As noted in the IIMM Rohingya report, Prime Minister U Nu's administration had Rohingya government ministers and parliamentary secretaries. There was a Rohingya Students' Association in the University of Rangoon. And in 1961, there was a Rohingya language radio broadcast on the public radio station of the Burma Broadcasting Service. In the early years after Burma's independence, there was an armed insurgency of Rohingya who sought to separate northern Rakhine State from Burma and join what was then called East Pakistan, or present-day Bangladesh. The Burmese army quashed that insurrection, whose fighters were referred to as Mujahideen. In July 1961, during the so-called Mujahid Insurgent Surrender Ceremony, Burma's Vice Chief of Staff of the Armed Forces, Brigadier General Aung Gyi, delivered a speech identifying the Rohingya as an ethnic group in Burma. His speech is at Annex 143 of the memorial. In relevant part, General Aung Gyi said the following, quote, "In central Burma, there are people who hold the view that people in this region are not Tai Yin Tha, or ethnic group native to the Union of Burma. These are false views. I want to openly and publicly tell you this. We consider the Rohingya people of Mayu district an ethnic minority integral to the Union of Burma. Let me be very precise about this. Those of you here ought to view yourselves as an ethnic minority of Burma. Only then will peace prevail in this region and in this country of ours." End quote. He went on to recognize the legitimate grievances of the Rohingya that had led to the insurgent movement in the first place, and declared that the persecution of the past was ending. Quote, "They said the Mujahideen rebellion broke out because of religious persecution. They said there was economic persecution. They said there was racial persecution. Yes, they are correct, as these rationales and explanations were true to a certain degree before. But that was the past. There is no more racial persecution, for we have emphatically and categorically recognized Rohingyas as an ethnic minority, making efforts for the progress and development of the Rohingya ethnic minority." End quote. Myanmar quotes from his speech in its rejoinder, using its own translation, to argue that General Aung Gyi referred to the Rohingya as the same ethnic group as existed across the border in present-day Bangladesh, and not as a distinct ethnic group in Myanmar. I will address the argument about the distinctiveness of the group shortly, but what is important is that Myanmar concedes that General Aung Gyi used the term Rohingya to refer to the Muslim majority population of present-day northern Rakhine State. Unfortunately, the commitment to recognition and inclusion and an end to persecution referred to in these speeches, the very same demands that the Rohingya have to this very day, did not hold true. Those who sought to exclude the Rohingya from the country soon regained power. In 1962, a military coup ousted the civilian government, and there began a long process of systematic persecution and discrimination against and exclusion of the Rohingya, extending and enlarging over the next several decades. This eventually culminated in the genocidal clearance operations of 2016 to 2018. Ms. Pasipanocha will go into further detail on the history of discrimination as one of the indicators of Myanmar's genocidal intent. I will now address why the Rohingya are plainly a protected group within the meaning of Article 2 of the Genocide Convention. Article 2 defines genocide as any of the acts listed therein that are, quote, committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. As articulated in Bosnia v. Serbia, the court has defined a group for purposes of the Genocide Convention as, quote, a collection of people who have a particular group identity, end quote, that is defined by, quote, positive characteristics, national, ethnical, racial, or religious, end quote, which can be identified through a, quote, combined subjective objective approach, end quote. The key objective factors include distinguishing well-established or immutable characteristics such as language, religion, citizenship, or hereditary physical characteristics. The key subjective factors include self-identification, perceived characteristics, and socio-historic context. Myanmar argues that these ethnical, racial, or religious characteristics must be such that the group is, quote, distinct from the rest of the world's population. There is no basis in the court's jurisprudence for this extreme position, which seems more motivated by Myanmar's desire to deny the existence of the Rohingya group than an effort to reasonably address the court's standard for defining the group under the convention. There is also no basis in the court's jurisprudence to apply, as Myanmar seeks to do, a high standard of proof applicable to findings of genocide to the identification of the group at issue. As the court made clear in Bosnia, all that is necessary is that the positive and objective characteristics of the group are such that it would enable the court to, quote, have in mind the identity of the group against which genocide may be considered to have been committed, end quote. The identity of the Rohingya group is clear. First, the Rohingya are rightly considered as an ethnical group given their language, culture, self-identification, and their identification as such by Myanmar and the United Nations. Clear evidence indicates that the Rohingya group speaks a common language, namely the Rohingya language. As noted, British and German ethnographic documentation from 1799, 1811, and 1815 refer to the Rohingya language as being spoken by Rohingya in Burma. Furthermore, a 2018 report from the NGO Translators Without Borders found that among Rohingya refugees surveyed, all, quote, said that they speak Rohingya, with 99% of them saying it is their primary language at home, end quote. That it is the, quote, only spoken language that all Rohingya refugees understand and prefer, end quote. Myanmar has not challenged this evidence. Rather, Myanmar argues that the Gambia has not established that the Rohingya speak a language not shared by others in the Chittagong division in Bangladesh. That is not something that the Gambia is required to prove. The fact that the Rohingya share this specific language is a positive characteristic that helps to establish their identity as an ethnical group. As the Gambia noted in the memorial, the Rohingya language is related to the Chittagonian dialect of Bangla and considered by anthropologist Dr. Pras Freeman to be a different dialect, one that the Rohingya view as central to their ethnic identity. Even Myanmar has noted the Rohingya's shared language in defining the group for purposes of its first report on implementation of the court's order on provisional measures. In that document, Myanmar noted that members of the group, quote, speak an Indo-European tongue, which is a variant of or is closely related to the Chittagonian dialect, end quote. The Rohingya also share a common culture. As discussed in the memorial, the Rohingya's shared culture includes communal organization around a mosque or group of mosques, an emphasis on family and community, and their own music, art, poetry, and foods. Myanmar again argues that these cultural characteristics may also be common to communities in Bangladesh, but that does not rebut the fact that these shared cultural characteristics allow for the identification of the Rohingya as an ethnical group in Myanmar. The subjective factor of self-identification is also highly relevant to the characterization of the Rohingya as an ethnical group. As noted, ethnographical reports from the 18th and 19th centuries document their historic self-identification as Rohingya. The UN High Commissioner for Human Rights has reported that Rohingya Muslims self-identify as a distinct ethnic group with their own language and culture, and claim a long-standing connection to Rakhine State. Other authoritative UN reports, like the reports of the UN fact-finding mission on Myanmar, have found that the Rohingya self-identify as such. As noted in the memorial, 85% of the Rohingya self-identified as such during Myanmar's 2013 Inquiry Commission on Sectarian Violence. And as noted earlier in my presentation, an estimated 1.1 million people were recorded as unenumerated in Myanmar's 2014 census because Myanmar did not allow them to self-identify as Rohingya in that census. Furthermore, Myanmar itself clearly recognized the Rohingya as an ethnic group in its early years after independence. The speeches of Prime Minister U Nu in 1954 and General Aung Gyi in 1961 clearly acknowledged and accepted the Rohingya identity as such. Moreover, Myanmar's long-standing discriminatory treatment of the Rohingya, which will be discussed in further detail by Ms. Pasipanochia, also confirms their distinct existence as a particular group in Myanmar. Finally, the international identification of the Rohingya as a distinct ethnic group by the United Nations and other states is a relevant subjective factor. In addition to the reporting by the UN entities noted above, the UN High Commissioner for Refugees has identified the Rohingya as a group since 1978. UN bodies like the UN General Assembly and the UN Human Rights Council have consistently referred to the Rohingya group by that name in dozens of UN resolutions, specifically addressing concerns over the treatment of the Rohingya, as have the UN Special Rapporteurs on the situation of human rights in Myanmar. And as noted in the Gambia's reply, the courts of several states, including Japan, France, and Australia, have all found persecution against the Rohingya based on their identity as such. All of these objective and subjective factors indicate that the Rohingya are widely recognized as an ethnical group within the meaning of Article 2 of the Genocide Convention. Second, the Rohingya are also a distinct group of Muslims for purposes of the Genocide Convention. It is not disputed that the Rohingya are predominantly Muslim. In fact, Myanmar consistently refers to the Rohingya by their religious identity as Muslims as a means of identifying them as a group. For example, as the court may recall, Myanmar's first agent in this case, the former state councilor Aung San Suu Kyi, referred to the Rohingya as, quote, Muslims living in Rakhine State during the oral proceedings on provisional measures. And in the first report on implementation of the court's order on provisional measures, Myanmar referred to the group as one of two, quote, sizable Muslim communities, end quote, in Rakhine State, the other being Muslims of the Kaman ethnicity. The historical record also confirms the close association of the Rohingya with Islam. Myanmar notes in its rejoinder that the British colonial census data refers to Arakan Mohammedans, that is, Muslims of Arakan, the territory that is now Rakhine State, which is one way in which the term Rohingya itself could be defined. The Muslim faith identity of the Rohingya group is central to their otherization and dehumanization in Myanmar, key parts of the genocidal process to which they have been and are being subjected. Several discriminatory laws, like restrictions on marriage and on the number of children couples could have, were explicitly targeted against Muslims, as you will hear in the presentation later today by Ms. Pasipanochia. And the pervasive hate speech that targeted the Rohingya often focused on the threat that they, as Muslims, allegedly pose to Myanmar's Buddhist majority population. You will also hear more on that later today. Myanmar argues that if there are non-Muslim Rohingya, then it cannot be considered as a religious group under the convention. But religion is not an immutable characteristic. So individuals who identify ethnically as Rohingya could be non-Muslim. They can convert to another religion or no longer believe in any religion. Many consider the small Hindu population in northern Rakhine State to be part of the Rohingya ethnic group. Indeed, in its counter-memorial, Myanmar states, "Not all Bengalis in northern Rakhine State are Muslim. A small minority are Hindu or Christian." Nonetheless, when the Gambia is referring to the Rohingya group, it is referring to that group based in part on its primary identity as a group of Muslims. Myanmar further argues that the Rohingya cannot be a separate religious group because they are not distinct religiously from the many Muslims in neighboring Bangladesh. But the existence of Muslims in Bangladesh is not relevant to defining a group in Myanmar for purposes of the convention. As we know from the court's decision in Bosnia, a geographical limitation combined with a religious identity can be used to define a group for purposes of the convention. For all these reasons, the Rohingya are a religious group within the meaning of Article 2 of the convention. Finally, the Rohingya are also a racial group under the convention. A racial group can be defined by objective characteristics like physical traits, as well as subjective factors like their socio-historic context and their perception by Myanmar authorities. Myanmar is a deeply race-based country. Citizenship is defined by belonging to 8 so-called national races. Myanmar's 135 officially recognized ethnic groups all fall within one of these 8 races. Despite the early recognition of the Rohingya as an ethnic group by Burma's political and military leaders, the Rohingya have since been excluded from these national races. Thus, Myanmar considers them to be a different race from these national races, which is effectively an admission that they are a distinct racial group. In describing the Rohingya, Myanmar officials have been documented as referring to their darker skin color and their being of, quote, Bengali stock. Myanmar's treatment of the Rohingya, which includes severe restrictions on movement and lack of access to healthcare, education, and livelihoods, is implemented by recognition of members of the group based on their physical appearance. The reality of this race-based treatment of the Rohingya, combined with their long history of persecution, constitutes a subjective factor allowing for their treatment as a racial group in Myanmar for purposes of the convention. Myanmar once again argues that these factors do not establish the Rohingya as a race separate from people of Bengali origin, but that is not what matters. so long as the objective and subjective characteristics allowed the court to identify the group at issue in Myanmar, the Rohingya can be considered as a racial group for purposes of the convention. In conclusion, Mr. President, the relevant objective and subjective factors establish without the shadow of a doubt that the Rohingya of Myanmar are an ethnical, racial, and/or racial group for purposes of Article 2 of the Genocide Convention. Thank you, Mr. President, members of the court, for your kind attention. Mr. Reichler will give the Gambia's next presentation, but this concludes the Gambia's presentations for the morning session. Thank you.
I thank Mr. Suleiman. This concludes this morning's sitting. The oral proceeding will resume this afternoon at 3 p.m. The sitting is closed.
La Cour.
Please be seated. The sitting is open. The court meets this afternoon to resume hearing the first round of oral argument of the Gambia on the merits in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar, 11 states intervening. I now invite Mr. Reichler to address the court. You have the floor, sir.
Thank you. Mr. President, members of the court, good afternoon. As adverted this morning, I will address you on the nature and reliability of the Gambia's evidence and the weight that it merits in your deliberations on whether the Gambia has proven its case that Myanmar committed genocide against the Rohingya people. The evidence itself will be presented by the speakers who follow me. My job is to explain why you should regard this evidence as trustworthy and convincing, and give it the weight that we say it deserves. As a preliminary matter, Mr. President, you may recall that I cut my morning speech a bit short in the interests of time. I will be including 2 excerpts from that speech this afternoon, and for the benefit of the esteemed interpreters, these inserts will come in paragraph 8 of the current speech after the 3rd line, and again after paragraph 36 of this speech. Mr. President, our case was filed in November 2019, shortly after the publication of a report in September of that year by a United Nations fact-finding mission appointed by the Human Rights Council and endorsed by the General Assembly. This was the second such report prepared by the FFM following its initial report of September 2018. Together, these reports comprise more than 600 pages and provide, inter alia, detailed descriptions of the so-called clearance operations carried out by Myanmar's army, the Tatmadaw, in northern Rakhine State, where the majority of the Rohingya group lived. In conducting their investigation and producing these reports, the FFM interviewed 1,294 victims, witnesses, perpetrators, and former Myanmar officials. They also reviewed satellite imagery, video and photo material, as well as internal documents, laws, policies, and directives of Myanmar. Taken together, the FFM's 2 reports appear to be the most voluminous, comprehensive, and detailed investigative reports ever produced by a United Nations fact-finding mission. These reports confirmed the Gambia's conclusion that Myanmar had committed genocide against the Rohingya Muslim group and that there was a compelling need to hold Myanmar accountable under the 1948 Convention by bringing these proceedings. After this case was initiated in 2020, the UN Human Rights Council established the Independent Investigative Mission for Myanmar to follow up on the FFM's work. According to its mandate, the IIMM would do so by collecting, consolidating, and analyzing evidence of the most serious international crimes and violations of international law committed in Myanmar since 2011, and to prepare files in order to facilitate and expedite fair and independent criminal proceedings. To this date, the IIMM has published 6 what it calls analytical reports, which are all part of the record of this case. And it has produced 41 witness statements, of which 12 have been introduced into evidence by the Gambia and 18 by Myanmar. Also part of the record is the affidavit of Assistant Secretary General Nicholas Koumjian, the head of the IIMM, in which he describes the mechanism's mandate and the work it has performed to date. The Gambia's evidence also includes reports from other authoritative United Nations bodies, including the Office of the High Commissioner for Human Rights and the Special Rapporteur on the Situation of Human Rights in Myanmar, as well as satellite imagery from UNISAT, the UN Satellite Center. The Gambia has also submitted no less than 50 reports from experienced and highly credible non-governmental organizations, including the United States Holocaust Memorial Museum, Médecins Sans Frontières, Amnesty International, Human Rights Watch, Physicians for Human Rights, Save the Children, the International Crisis Group, and Fortify Rights, as well as a report produced in 2018 by the United States Department of State. Not least, the Gambia has submitted 48 signed witness statements from victims and eyewitnesses providing first-hand testimony of the events surrounding Myanmar's clearance operations in the Rohingya villages of northern Rakhine State. In 14 of these, the names have been redacted at the request of the witness, who expressed fear of reprisal by Myanmar against themselves or family members remaining in the country. Names do appear in the other 34 witness statements. 3 of the witnesses will testify here next Wednesday and Thursday. We place special emphasis on the reports by the FFM and IIMM, including all of the underlying material on which the reports are based. While the rest of our evidence, including the witness testimony, is highly probative and significant in itself, its value also lies in its consistency with and confirmation of the findings of the FFM and the IIMM, which serves to underscore and enhance the reliability and weight of the FFM's 2 comprehensive reports and the IIMM's 6 analytical reports. All of these reports, from the FFM and the IIMM, from UN OHCHR and the special rapporteurs, from the NGOs and the United States, as well as the witness statements, corroborate one another and provide strong assurances of the evidence, reliability, and convincing nature. We submit that all of these reports come from disinterested third parties, especially those from United Nations bodies. They should be given significant evidentiary weight by the court in determining the facts of the case for this reason. Myanmar disagrees. It has 3 words for all of these reports and statements, quote, no evidential weight. They argue that our evidence should be rejected in its entirety by the court because none of it arose from judicial proceedings such as those conducted by the ICTY, cited by the court in the Bosnia and Croatia cases. For Myanmar, the court cannot rely on the reports of the UN fact-finding mission or of any other independent and authoritative non-judicial entity without, in their words, delegating its fact-finding responsibility to such third parties. Mr. President, it doesn't take a Newton, Professor Michael of Vanderbilt, or Sir Isaac of the English Enlightenment to appreciate the lack of gravity in Myanmar's argument. With the evidence so overwhelmingly against it, Myanmar has no choice but to invent a reason, no matter how unreasonable, to disqualify that evidence. Myanmar has got it completely wrong. In fact, the court has regularly relied on the reports of independent fact-finding bodies, especially UN bodies, to assist it in its own determination of the facts. To be sure, as its jurisprudence makes clear, it has done so only after carefully scrutinizing these reports to ensure that they meet the standards articulated in its case law for establishing their reliability. Doing so here would be consistent with the court's long-standing practice. Earlier today, I cited some examples, including the court's express reliance on the report of the Secretary General in the Bosnia case, and the consideration it gave to the special rapporteur's report in the Croatia case. In fact, the court's jurisprudence is replete with examples of its reliance on independent and authoritative reports from United Nations bodies and from other highly credible third parties, including other international organizations and NGOs, in finding the facts of a particular case. A brief tour through that jurisprudence demonstrates the court's consistent approach to this kind of evidence. I begin where I myself began some 40 years ago with the case of Nicaragua versus United States. The 1986 judgment in that case is one of the first in which the court took the occasion to elaborate generally on its role as finder of fact. The court made it clear that, quote, its role is not a passive one. It has freedom in estimating the value of the various elements of evidence. The court identified two forms of evidence which it regarded as, quote, prima facie, of superior credibility. One, the evidence of a disinterested witness, that is, someone who is not a party. And two, evidence of a party which is against its own interest. It is the first of these categories that is of most interest to us here, the, quote, superior credibility of the evidence supplied by a disinterested witness who is not a party to the proceedings. This is the basis for the court's reliance on evidence from disinterested third parties, when the circumstances demonstrate to the court's satisfaction that such evidence has probative value. And such was the case in DRC v. Uganda, in particular with regard to reports by United Nations bodies, specifically reports by the Secretary General and the Special Rapporteur, which were submitted by the DRC and objected to by Uganda. The court determined that it would consider this evidence because it was appropriate to, quote, give weight to evidence that has not, even before this litigation, been challenged by impartial persons for the correctness of what it contained. On this basis, it found that the UN reports furnished, quote, sufficient and convincing evidence to support the DRC's claims regarding the looting of its natural resources. The court also placed reliance on the findings of the Porter Commission, a judicial-like inquiry conducted under the auspices of the Ugandan government, to reach its conclusion. Unlike the findings of the Porter Commission, the UN reports were not based on witness testimony taken under oath or subject to cross-examination. In objecting to them, Uganda argued that the United Nations, quote, did not have a mission appropriate to investigations of a specifically legal character, and that its reports were thus, quote, inappropriate as a form of assistance in any assessment accompanied by judicial rigor. If this sounds familiar, it's because it's not dissimilar to the argument that Myanmar makes here in objecting to the Gambia's evidence. The court rejected Uganda's argument and decided that it would, quote, take into consideration evidence contained in certain United Nations documents to the extent that they are of probative value and are corroborated, if necessary, by other credible sources. In doing so, the court found that quote, a coincidence of reports from credible sources was sufficient to establish that Ugandan forces had committed human rights violations and breaches of international humanitarian law. In particular, it found that the reports of the Secretary General and the Special Rapporteur were, quote, consistent in the presentation of facts, support each other, and are corroborated by other credible sources, and thus constituted what the court called, quote, convincing evidence. I come next on the tour to the Bosnia case. This morning I mentioned the court's reliance on the Secretary General's 113-page report on the fall of Srebrenica, as well as on the findings of the ICTY. In regard to the Secretary General's report, the court determined that, quote, the care taken in preparing the report, its comprehensive sources, and the independence of those responsible for its preparation all lend considerable authority to it. In reaching this determination, the court noted that the comprehensive sources on which the report relied included interviews conducted on a non-attribution basis with approximately 80 people who had knowledge of the events, on accounts from survivors, on satellite imagery, on other UN reports, on information from governmental sources and NGOs, on information from press reports, and on forensic evidence from the ICTY. In the Croatia case, as I also mentioned this morning, the court determined that a report by the UN Special Rapporteur submitted by Serbia should be given, quote, evidential weight, owing to the, quote, independent status of its author and the fact that it was, quote, prepared at the request of organs of the United Nations for purposes of the exercise of their function. More recently, in Ukraine v. Russia, where Ukraine submitted reports by the Secretary General, the High Commissioner for Human Rights, and the CERD Committee to prove that Russia discriminated against Crimean Tatars in occupied Ukrainian territory, the court, quote, attributed considerable weight to reports of several United Nations organs and monitoring bodies, as well as a report by the Council of Europe. In its 2024 judgment in that case, the court explained that it, quote, generally ascribes particular weight to reports by international organizations that are specifically mandated to monitor the situation in a given area. The court has taken a similar approach in its advisory proceedings. Although these are not contentious cases, the court's advisory opinions are authoritative statements of international law, and the factual predicates for its rulings are often critical. There is no reason to assume that the court has employed a lower threshold of reliability in assessing the evidence in such cases. In fact, its jurisprudence tells us that it employs the same principles as in contentious cases. In its opinion on the legality of Israel's policies and practices in the occupied Palestinian territory, for example, the court relied on various reports and statements by UN organs and bodies, including the Secretary General, the High Commissioner for Human Rights, the Independent International Commission of Inquiry, and the Special Rapporteur for the occupied Palestinian territory, explaining that, quote, "These reports rely on a variety of sources, including first-hand accounts, to set out a detailed factual analysis of Israel's settlement policy." In the same 2024 advisory opinion, the court cited as precedent for its reliance on these UN reports its practice in contentious cases, including expressly the DRC, Bosnia, and Ukraine cases. Consistent with its approach in those cases, the court explained that in determining the probative value of such third-party evidence, it takes into account, one, the source of the item of evidence, for instance, partisan or neutral; two, the process by which it has been generated, for instance, an anonymous press report or the product of a careful court or court-like process; and three, the quality or character of the item, such as statements against interests and agreed or uncontested facts. With regard to the weight to be given to such evidence, the court considers, one, the care taken in preparing a report, the comprehensiveness of its sources, and three, the independence of those responsible for preparing it. Applying these criteria to the evidence submitted by the Gambia, especially the FFM and the IIMM reports, there can be no doubt of their probative value or that they merit great evidentiary weight. First, let us consider the independence, neutrality, and lack of partisanship of those responsible for preparing these reports. The FFM was an independent body established by the Human Rights Council, composed of three prominent individuals, distinguished by their experience and neutrality: Marzuki Darusman of Indonesia as chairperson, and Radhika Kumaraswamy of Sri Lanka, and Christopher Sidoti of Australia as members. A secretariat was recruited by the Office of the United Nations High Commissioner for Human Rights. The core team was composed of a coordinator, a fact-finding team leader, and 5 human rights officers, a legal advisor, a military advisor, a sexual and gender-based violence advisor, a security officer, and 2 language assistants, in addition to administrative support. The FFM's members and staff were mandated to employ only, quote, the best practices established for fact-finding missions, as detailed in the OHCHR's published Guidance and Practice for Commissions of Inquiry and Fact-Finding Missions on International Human Rights and Humanitarian Law. The best practices, these best practices, require strict adherence, quote, to the principles of do no harm, independence, impartiality, objectivity, transparency, and integrity, end of quote. Myanmar has produced no evidence that the mission failed to adhere to these principles. Second, in regard to the comprehensiveness of the FFM sources, as I have already mentioned, the sources relied upon by the mission included confidential interviews conducted by the mission or its staff with more than 1,200 victims, witnesses, perpetrators, and former Myanmar officials with direct knowledge of the issues; satellite imagery, authenticated video and photo material, publicly available admissions of relevant facts by Myanmar officials, laws, policies, and directives of Myanmar, internal Myanmar documents, and statistics, surveys, and other quantitative information generated by Myanmar or the United Nations. Third, the FFM's reports were prepared with diligence and care. As stated in the 2018 report, the FFM carefully assessed, quote, the reliability and credibility of each source, and, quote, considered the information's relevance to the fact-finding work, its internal consistency and coherence, and its consistency with and corroboration by other information, among other factors. In particular, individual cases or incidents contained in the report are based on at least one credible source of first-hand information, which was independently corroborated by at least one other credible source of information. Specific major incidents, such as those set out in Chapter 5 on Rakhine State, are based on multiple accounts from eyewitnesses and victims, allowing for in-depth fact-finding and detailed event reconstruction. Where the report describes patterns of conduct, these are based on multiple credible sources of first-hand information, which are consistent with and corroborated by the overall body of credible information collected. For its 2018 report alone, the FFM, quote, conducted 875 in-depth interviews with victims and eyewitnesses in Bangladesh, Indonesia, Malaysia, Thailand, and the United Kingdom, taking care to, quote, diversify its sources of information by interviewing, quote, individuals from different ethnic and religious backgrounds and a number of members of non-state armed groups, as well as some former officials of Myanmar state institutions, end of quote. For its 2019 report, the mission conducted more than 400 interviews with victims and eyewitnesses. When selecting witnesses, the FFM employed various methodological approaches, including random selection, such as visiting different areas of a refugee camp or different refugee centers without prearrangement, prioritizing those, quote, most recently arrived from Myanmar to ensure the receipt of fresh information, quote, targeting interviewees to corroborate specific incidents or patterns, and striving, quote, to only speak with persons who had not previously spoken with any other organization or media outlet. To further ensure the reliability of the evidence obtained from witnesses, the FFM factored in, quote, the witness's political and personal interests, potential biases, and past record of reliability, where known. The witness's apparent capacity to recall events correctly, considering his or her age, trauma, how far back the events occurred, and so on. The position of the witness in relation to the subject of the information, where and how the witness obtained the information, and the reasons for which the witness provided the information. Myanmar does not and cannot dispute any of this. It cannot disprove the independence of the FFM, the comprehensiveness of its source of evidence, or the meticulous care it displayed in its collection of evidence and the preparation of its reports. Myanmar does not and cannot tell us anything that would diminish the high probative value or the significant evidential weight to which these reports are entitled. Likewise, for the IIMM's reports. The IIMM, too, is an independent body created by the UN Human Rights Council. Its investigations are carried out by experienced investigators, analysts, and legal officers under the strategic direction and oversight of an Assistant Secretary General, Nicholas Koumjian. Thus far, the IIMM has published 6 reports. 1 on Myanmar's propagation of anti-Rohingya hate speech on Facebook. 2 on its encouragement of Buddhist settlement into Rakhine State to replace or dilute the Rohingya population. 3 on its refusal to investigate and punish gender-based crimes against the Rohingya. 4 on ARSA's weapons possession and use. 5, on Myanmar's abusive detention of Rohingya in Butadong prison, and 6, on its destruction of Rohingya villages. All 6 reports reflect the due care attendant to best practices in international investigations. They plainly meet the court standards, the independence of the authors, the comprehensiveness of their sources, and the care with which they were prepared for giving significant evidentiary weight to UN investigative reports. Mr. President, we do not suggest that the court should accept and attribute the weight they deserve to the FFM reports and the IIMM reports relied on by the Gambia simply because they were produced by United Nations bodies. The court is the ultimate finder of facts, and its role is not a passive one. It must determine for itself, in the exercise of its discretion, the reliability and weight of the evidence submitted to it by the parties. Our contention is that applying the well-established criteria for evaluating evidence emanating from third-party sources, as set out consistently in the court's jurisprudence, it is inevitable that the FFM and IIMM reports be given great evidentiary weight. We note that the joint interveners, Germany, France, Canada, Denmark, the Netherlands, and the United Kingdom, have expressed the same view. Specifically, certain sources must be regarded as having particular probative value in establishing the elements required to demonstrate the existence of genocide, including the facts that allow the court to draw inferences as to specific intent. In this regard, the declarants submit that reports generated by the United Nations, such as reports produced by fact-finding missions, commissions of inquiry, and reports that the Secretary General of the United Nations may prepare for the United Nations Security Council or the General Assembly, can have special importance. Indeed, such reports can be particularly credible because they emanate from a disinterested witness. Myanmar alone disagrees. As I said earlier, they take the extreme position that the FFM and IIMM reports have, quote, no evidential weight whatsoever. Zero. Nothing. Rien. Of course they take this position. They know that the 2 FFM and 6 IIMM reports provide compelling evidence that Myanmar committed the actus reus of genocide and acted with genocidal intent against the Rohingya group. Their only hope of avoiding an adverse judgment by the court is somehow to disqualify that evidence. To that end, Myanmar takes 3 different swings at the FFM and IIMM reports. Every one of them misses by a wide margin. First, Myanmar argues that these reports are, quote, incomplete and one-sided because Myanmar itself did not participate in the investigative process. Now, that is far from a convincing argument, but we can't help but be impressed by its audacity. It is true that Myanmar did not participate in the investigative process. But let us not forget that this was because Myanmar refused to cooperate with the United Nations in any way, including by refusing to allow any FFM or IIMM personnel entry into its territory or to accommodate any of their requests for information or access to witnesses. In other words, Myanmar now invokes its own refusal to cooperate to undermine the value of the reports. Yet it is undisputed that the FFM reached out to Myanmar on at least 5 occasions to request in-country access. And it submitted to Myanmar a detailed list of questions to obtain information and documents, and that Myanmar refused to respond to any of these overtures. It is also uncontested that prior to the publication of each report in 2018 and again in 2019, the FFM shared its draft findings and recommendations with Myanmar, offering an opportunity to comment or make factual corrections, and that again, Myanmar made no response. Similarly, as Assistant Secretary General Kumjin attests, as of 17 November 2025, the IIMM had issued 26 requests for information to the government of Myanmar, quote, including information that the Myanmar authorities may deem to be potentially exonerating, such as information on alleged attacks by ARSA. However, quote, the Myanmar authorities have not responded to any of these requests. How can they now complain to the court about allegedly one-sided reports when they have been given multiple opportunities to present their side and review the materials, but they refuse to do so? In any event, both the FFM and the IIMM have attempted in good faith to obtain evidence from sources close to Myanmar that might be supportive of Myanmar's position, including evidence on the nature of the threat supposedly posed by ARSA. And they have included in their reports Myanmar's public statements explaining the objectives and execution of the clearance operations in the Rohingya villages of northern Rakhine State, and denying that their intention was to destroy the Rohingya group. Myanmar's refusal to cooperate with these investigations cannot be a basis for disqualifying or diminishing reports by United Nations body that satisfy all the requirements set by the court for reliability and evidentiary weight. Imagine the precedent this would set if it were otherwise. States accused of serious breaches of international law would have a free pass to avoid accountability simply by refusing to allow international investigative missions into the country and rejecting their requests for cooperation. This appears to have been Myanmar's strategy in this case. It should not be rewarded for its obstructive behavior. Myanmar's second argument is that the court's reliance on the FFM, IIMM, and other reports submitted by the Gambia would be what they call an abnegation of its judicial function, because it would amount to a, quote, delegation of its fact-finding responsibilities to other non-judicial entities. They're wrong about that too. We say when the court receives, reviews, and decides to accord evidentiary weight to the report of an independent and authoritative United Nations body, that is a legitimate exercise of its fact-finding responsibility, not an abnegation of it. We are supported in this by the long line of cases I reviewed earlier, in each of which the court determined, upon its own analysis and according to its own criteria, that such reports were reliable and should be accorded due evidentiary weight. Myanmar reads these cases selectively and draws a different, we say, erroneous conclusion. They say the case law establishes that the court may rely on third-party findings only when they result from judicial proceedings, like the findings of the ICTY cited by the court in Bosnia and Croatia, or from judicial-like proceedings, like the findings of the Porter Commission in DRC v. Uganda. They completely ignore the court's reliance on the Secretary General's report in Bosnia, the Special Rapporteur's report in Croatia, and the reports of the Secretary General and the Special Rapporteur, among others, in DRC v. Uganda. Nor do they have an answer for the Court's reliance on the reports of the High Commissioner for Human Rights and the CERD Committee in Ukraine v. Russia. Myanmar's argument not only runs counter to the Court's jurisprudence and long-standing practice, it also misperceives how the Court necessarily conducts its business. The mission of the Court is to resolve disputes peacefully between states in accordance with international law. It is not to determine guilt or innocence of individual perpetrators or impose sentence on them. That is the role of the International Criminal Court, which is a criminal court empowered to deprive the accused of their liberty and property, must afford them their due process rights to directly confront and cross-examine the witnesses against them. Those are not the rules of procedure that apply here, and they never have been. Of course, respondent states are entitled to cross-examine the witnesses who do appear in the court to testify against them. But there is no right to exclude evidence obtained from witnesses by authoritative and independent entities, especially UN bodies, whose reports the court, in the exercise of its judicial function, determines are entitled to evidentiary weight. It would be impractical and serve no higher purpose for the rules of criminal procedure to be imported into the ICJ. In this case, it is not disputed that the FFM reached its factual findings after interviewing more than 1,200 victims and witnesses from scores of Rohingya villages where the clearance operations were carried out. If the court could not make findings of fact without hearing the testimony of these witnesses firsthand in the Peace Palace, in a situation where there have been no prior prosecutions by a war crimes tribunal, how many of them would it have to hear to find that the clearance operations were carried out with a similar modus operandi in at least 54 different villages, as the fact-finding mission concluded? That extreme brutality and sexual violence were inflicted in all of these villages. That nearly 200 Rohingya villages were burned to the ground by the Tatmadaw. From how many witnesses would the court have to hear to determine what happened in a single one of these villages, let alone scores of them? In cases of mass atrocity or injury, be it by genocide, war crimes, crimes against humanity, or cross-border environmental catastrophe, hearings involving examination, cross-examination, and redirect examination of the requisite number of witnesses would occupy the court full time, for several months at least. The effect of Myanmar's effort to put a straitjacket on the court in regard to its ability to rely on investigative reports by UN and other authoritative bodies would be to make it all but impossible for the court to hold a state accountable under the Genocide Convention, absent the state's prior submission to the jurisdiction of a war crimes tribunal, an effect which Myanmar apparently does not find inconvenient. I think we can safely assume that it has no intention of subjecting Senior General Hague and his accomplices to such proceedings. There is no benefit in the approach Myanmar urges you to take. It is true that this court is uniquely a court of first as well as last instance. But why shouldn't the court, in its wisdom and when the circumstances warrant, continue to rely on convincing evidence responsibly and reliably obtained by independent, impartial, and authoritative third-party entities, especially other organs of the United Nations, in making its findings of fact? If the court determines to quote from its July 2024 advisory opinion, that, quote, the care taken in preparing a report, the comprehensiveness of its sources, and the independence of those responsible for preparing it are such as to ensure reliability and to warrant evidentiary weight. Why should the court be precluded from treating it as such? We say, far from an abnegation of its responsibility, this is an entirely proper and necessary exercise of that responsibility, and in many cases, the only practical way in which its job of fact-finding can be done. Mr. President, Myanmar is undoubtedly aware of the weakness of its attempt to turn the ICJ into the ICC and the improbability of your willingness to redefine your mandate. That is why they expend so many pages of the written pleadings purporting to find technical flaws in the UN reports. In doing so, they give nitpicking a new meaning. For the most part, these alleged flaws are not even nits, but micro nits, or even nano nits, where they exist at all. None of them can detract from the reliability of the Gambia's evidence or the evidentiary weight to which it is entitled. For example, Myanmar complains that the FFM's reports fail to set out their methods of work. But in fact, the reports have entire sections dedicated precisely to that purpose, and they confirm that in carrying out their investigation, the mission's members and staff scrupulously employed and adhered to the best practices spelled out in the OHCHR's guidelines. Myanmar also claims that the interviews of victims and witnesses conducted by the FFM, quote, appear to have been cursory. How do they know this if they refuse to participate in the interviews? The answer is they speculate. They say, for example, quote, given the very small size of the FFM staff, it is apparent that the interviews of 875 people in that very short space of time can hardly have been in depth, and that the process can hardly have been careful and detailed. This is pure conjecture, and it is belied by the facts. According to its 2018 report, the mission deployed to the refugee camps in Bangladesh in September 2017, immediately after the clearance operations had been conducted, and interviewed many of the newly arrived survivors who had witnessed them. Further interviews were conducted during numerous additional field missions between September 2017 and July 2018, which lasted many weeks. For the 2019 report, the mission made 6 field missions to collect evidence between February and June 2019. There is no reason to believe that the amount of time spent or the number of staff involved were inadequate to the task at hand. Again, both reports confirm that the mission's interviews were conducted in conformity with the OHCHR's best practices. Myanmar also attempts to undermine the probative value of the 2018 and 2019 reports on the further speculation that the victims and witnesses interviewed by the FFM were fearful of ARSA and subject to its influence. The FFM did not ignore this possibility. That is why, as stated in its 2018 report, it took particular care not to take the interviewees' statements at face value, but to take into account, quote, the witness's political and personal interests, potential biases, and past record of reliability, as well as, quote, where and how the witness obtained the information he or she was providing, and, quote, the reasons for which the witness provided the information. Myanmar offers no evidence, none, that any of the witnesses interviewed by the FFM was in fact influenced by arson. Myanmar has much less to say about the 6 IIMM reports. It argues only that they are, quote, not the best evidence of the facts stated in them because they provide, quote, secondhand descriptions of the evidence. But this cannot be a reason for distrusting the reports. All investigative reports, including those on which the court has previously relied, are necessarily secondhand accounts, since the investigators who author the report are not themselves eyewitnesses to the events that are described. What matters, as the court has explained, is their independence, the comprehensiveness of their sources, and the care they have taken in investigating and reporting the facts. Myanmar has nothing to say about any of this in respect of the IIMM's reports. Instead of attacking those reports, Myanmar criticizes the Gambia for not placing more reliance on them in our written pleadings, suggesting that our alleged omission constitutes an admission that they are not supportive of our claims. It is inexplicable, they claim, that the Gambia has not sought to base its claim on materials provided by the IIMM. Frankly, we don't know what they're talking about. First of all 6 of the IIMM's reports are very supportive of our case. In fact, we annexed 5 of these reports to our reply and quoted extensively from them within it. The only one we did not address was published in September 2025, 16 months after our reply was submitted. You will hear about that one too from my colleagues. I turn next and more briefly to the evidence contained in the reports of non-governmental organizations. The Gambia has submitted 50 such reports, including from leading human rights organizations with well-earned reputations for expertise, independence, and objectivity, some of which I identified earlier in my speech. The Gambia does not rely on these reports as its principal sources of evidence, but consistent with the court's jurisprudence, as material that corroborates and confirms the evidence contained in the 2 reports by the fact-finding mission and the 6 reports by the IIMM. The Gambia considers it impressive that these reports, more than 4 dozen of them, fully support the factual findings and the conclusions reached by the 2 United Nations bodies. Myanmar cannot credibly object to giving them evidentiary weight because it too has offered into evidence certain NGO reports, including from 2 of the same sources relied on by the Gambia, Amnesty International and the International Crisis Group. Myanmar relies on their reports to support its narrative on ARSA. We, of course, do not object to their reliance on these reports, although we read them differently. In fact, we ourselves have called attention to the following passage from the Amnesty International report that Myanmar submitted as Annex 268 to its counter memorial. Myanmar's security forces, and in particular the military, responded to the attacks and subsequent clashes with an unlawful and grossly disproportionate campaign of violence marked by killings, rape, and other sexual violence, torture, village burning, forced starvation tactics, and other human rights violations and crimes under international law, all of which has been well documented by Amnesty International and others. The military's attacks, which targeted the entire Rohingya population living in northern Rakhine State, have been both widespread and systematic. Nothing can justify such violations. This, I emphasize, is from their evidence. I come next and last to the probative value of the witness statements that have been submitted. there should be no debate about the value of the witness statements obtained by the IIMM, which it shared with both parties. As I pointed out earlier, there were 41 such testimonies, of which the Gambia has submitted 12 and Myanmar has introduced 18. The IIMM redacted the names of these witnesses for their protection. Nevertheless, both parties rely on them, thereby waiving any objection they might have to the court's reliance on witness statements that have been redacted in this manner and for this purpose. As previously noted, the Gambia has also submitted another 48 signed witness statements, 34 in unredacted form, and 14 with the names and other identifying information redacted at the request of the witnesses for their own protection. Notably, none of the statements from Rohingya victims or witnesses were obtained by the Gambia. All were obtained by non-parties to these proceedings. 44 of the statements obtained by the Gambia were obtained by 44 of the statements submitted by the Gambia were obtained by an independent organization, Legal Action Worldwide, which relied on a team of senior criminal investigators, including members of the Royal Canadian Mounted Police. The Gambia submits that these statements, which further corroborate the findings of the UN fact-finding mission and the IIMM, have significant probative value and are entitled to evidentiary weight. As the court said in Croatia, quote, although some of these statements were made several years after the events in question, they are by victims or eyewitnesses of acts of ill treatment, torture, and rape. The court gives evidential weight to these statements. Despite this, Myanmar objects to them. It objects to all of the witness statements where the names have been redacted, except, of course, for those on which Myanmar itself relies. In this regard, we refer again to what the court said about unsigned statements in Croatia. Quote, the absence of signatures of the persons who made the statements or took them does not in principle exclude these documents. However, the court has to ensure that documents which purport to contain the statements of individuals who are not called to give oral testimony faithfully record the evidence actually given by those individuals. That assurance exists here because the statements are in fact signed by the witnesses, with some of the signatures subsequently redacted and vouched for by the entities that took the statements. Myanmar objects in particular to the statements obtained by the Royal Canadian Mounted Police on the ground that Canada is biased against Myanmar due to its intervention in these proceedings, and the RCMP must therefore be regarded as partisan rather than neutral. According to Myanmar, this requires that the statements it obtained be disregarded by the court because, quote, Canada overtly sides with the Gambia against Myanmar. This is a rather broad definition of partisan, too broad in our estimation. But if witness statements obtained by a party or an intervener are to be disregarded, then the 28 witness statements obtained by Myanmar itself for the purposes of this case and submitted as annexes to its counter-memorial and rejoinder would certainly fall into that category. As the court said in Bosnia, quote, it will treat with caution evidentiary materials specially prepared for this case and also materials emanating from a single source. In Croatia, the court declined to give evidential weight to statements obtained by the Croatian police, where, quote, the words used appear to be those of the police officers themselves. Are written statements given under the watchful eye of the Tatmadaw any more reliable? The question answers itself. In contrast to the witness statements obtained by Myanmar, as I have indicated, none of the statements submitted by the Gambia were obtained by the Gambia itself. Mr. President, members of the court, I have given you the reasons why we believe you should consider the Gambia's evidence to be reliable and to merit great evidentiary weight. I trust that this will be of assistance to you as you hear and consider that evidence in the course of these proceedings, commencing with the next speaker. I thank you again for your kind courtesy and patient attention, especially for the second time in the same day, and I ask that you please call my esteemed colleague, Ms. Pasipanoja, to the podium, unless, Mr. President, you believe it would be appropriate to take the afternoon break at this time.
I thank Mr. Reckler for his statement. I now invite Ms. Pasipanoja to address the court. You have the floor, madam.
Mr. President, distinguished members of the court, it is a privilege to appear before you on behalf of the Gambia. For decades, Myanmar built a discriminatory state system that denationalized the Rohingya, suppressed births and marriages, and made life impossible through segregation, confinement, and deprivation. That system did not arise by accident. It was designed to reduce the Rohingya's population in Rakhine State and ultimately facilitate their destruction as a group. As Raphael Lemkin explained, genocide is a coordinated plan of different actions aiming at the destruction of essential foundations of the life of national groups, with the aim of annihilating the groups themselves. The objectives of such a plan would be disintegration of the political and social institutions of culture, language, national feelings, religion, and the economic existence of the national group, and the destruction of the personal security, liberty, health, dignity, and even the lives of the individuals belonging to such groups. That is precisely what Myanmar has done to the Rohingya. I will show that Myanmar built and then tightened a comprehensive, legal, administrative, and coercive system to reduce and eliminate the Rohingya in Rakhine State. I will highlight 5 steps in that system. First, in the years following independence, Myanmar recognized the Rohingya as citizens, office holders, and participants in public life. Second, after the 1962 military coup, the state recast the nation along racial lines, culminating in the 1982 citizenship law, which excluded the Rohingya from the so-called national races and laid the legal groundwork for mass denationalization. Third, the 1982 law was implemented to strip the Rohingya of their rights through discriminatory registration, arbitrary decision-making, and violent citizenship verification campaigns, expelling hundreds of thousands of Rohingya from Myanmar. Fourth, from 1993 onward, Myanmar sought to suppress Rohingya births and family life through marriage permits, child limits, and denial of birth registration. Fifth, beginning in 1997, Myanmar segregated and confined the Rohingya in camps and ghettos, severely restricted movement, and deprived them of food and health care. As the UN fact-finding mission observed, taken together, these discriminatory policies indicate Myanmar's genocidal intent. Mr. President, Myanmar denies the Rohingya's very existence as a constituent group of its nation. It has steadfastly refused to refer to them by name throughout the many years of this proceeding. That is consistent with a 1993 statement by its permanent mission to the United Nations. I quote, "The so-called Rohingya never belonged to the national races or national racial groups of Myanmar. The Rohingya do not exist in Myanmar, either historically, politically, or legally. nor do they in any way represent any segment of the population in Myanmar, including those professing the Islamic faith. But as Mr. Suleiman made clear this morning, the historical record shows otherwise. Myanmar's first Prime Minister stated in 1954 that, quote, located to the southwest of the Union, Burma, is Rakhine. There are 2 townships there, Mang Dao and Butidao. The majority of the nationals residing in those townships are Rohingya, who are Muslims. The Rohingya were an integral part of Burmese society. Accordingly, 2 Rohingya served on the country's first governing body, the Constituent Assembly, in 1947. In the photo on the screen, you see Rohingya leader Mr. Gaffa with Burma's Prime Minister U Nu and Burma's founding father, Mr. Aung San. Documentation collected by the United States Holocaust Memorial Museum on its online exhibition entitled Burma's Path to Genocide reflects the integration of the Rohingya in Burmese public life. The Rohingya held elected office, taught in schools, served as police officers, judges, doctors, and worked as farmers and fishers. In this 1950s photo before you now, the Rohingya Students Association of Rangoon University appears with Mr. Rashid, a cabinet minister and founding father of Burma. In the next, you see Irshad, now over 100 years old and living in a refugee camp in Bangladesh. He served as a Rohingya radio broadcaster in the 1960s, when Burma Broadcasting Services provided Rohingya language programming alongside airtime for other ethnic groups. And in the next, you see examples of national registration cards that the Rohingya held, just like other nationals. As Rohingya National Member of Parliament Yu Kwa Min explains, holders of those cards had the right to possess immovable properties, the right to public jobs, insurance, social security, and professional education. He also recounts how Rohingya representatives were invited to Union Day celebrations as part of the Union races. In sum, the Rohingya community had a recognized place in Myanmar's post-independence nationhood. The UN fact-finding mission confirms that, quote, most Muslims who then lived in what currently constitutes Rakhine State were therefore included, whether their ancestry could be traced to pre-colonial times or whether they were colonial-era migrants from the region. The exclusion of the Rohingya from the Burmese society began after the 1962 military coup. As Professor Cheeseman, director of the Myanmar Research Center at the Australian National University, explains, at that time, the concept of national races, Tainyintha in Burmese, assumed an unprecedented place in state lexicon, and thereafter in the state-building program. General Ne Win's regime began to construct a vision for a utopian Burmese society defined by a unified set of national races. Professor Cheeseman chronicles the various books on national races that were published by General Ne Win's political party in the 1960s, and how following the return of his military regime in 1988, national races were invoked on every broadcast, publication, and at every major event. A few days before the promulgation of the 1982 citizenship law, General Ne Win declared, I quote, racially, only pure-blooded nationals will be called citizens. That statement captures the decisive shift of the 1982 law. Citizenship ceased to be a civic status tied to residence and descent and became primarily contingent on racial categorization. Section 4.2 of the 1948 Union Citizenship Act had provided that any person would be deemed a citizen if their ancestors had for at least 2 generations made a territory of the Union their permanent home, and both the person and their parents were born there. Reflecting the insignificance of race, national registration cards did not identify the cardholder's race. By contrast, the 1982 law anchored citizenship in national races, identifying citizens persons belonging to 8 ethnic groups that were later divided by military instruction into 135. Neither the 1982 law, the military instruction, nor any other state communication ever explained or justified Myanmar's formulation of the national races. Crucially, the Rohingya were excluded from both lists. That exclusion, coupled with the discriminatory implementation of the law, denationalized roughly 1 million Rohingya, creating, as the French representative to the UN Security Council mission to Bangladesh observed, the largest group of stateless persons in the world. History shows that utopian projects of race and nation begin with bureaucratic reclassification and lead ultimately to deprivation, expulsion, and death. As Myanmar notes, Section 6 of the 1982 law preserved existing citizens. On paper, that should have prevented mass statelessness. In practice, it did not. As Professor Cheeseman explains, registration officers apparently acting on orders from superiors refused to re-register people who were entitled to pink cards or citizenship scrutiny cards. Even university graduates and civil servants who had already had to pass through numerous background checks were denied the cards. The UN fact-finding mission identifies wide administrative discretion that enabled discriminatory and arbitrary implementation, such as provisions permitting those enforcing the law to act without providing reasons for their decisions. Even Myanmar's own Advisory Commission on Rakhine State reported in 2017 that out of roughly 1 million stateless Muslims in Rakhine State, only about 4,000 were recognized as citizens or naturalized citizens. Thus, over 99% were denied even associate or nationalized citizenship. This bureaucratic assault was accompanied by violence. In 1978, Operation Nagamin, or Dragon King, ostensibly a registration exercise ahead of a census, saw military assaults and destruction of property that led to the flight of over 200,000 Rohingya to Bangladesh. The image on the screen was taken then. Another operation, Operation Pitaya, which means clean and beautiful nation, was carried out in Rakhine State between 1991 and 1992. The information received by Special Rapporteur Dalmeda indicated that this operation entailed extrajudicial executions, torture, arbitrary detention, and forced disappearances, rape, forced labor, robbery, arson, eviction, land confiscation, and the destruction of mosques, forcing flight at a rate of 5,000 to 7,000 persons per day by March 1992. A subsequent report by UN Secretary General Boutros Ghali recorded over 250,000 Rohingya fleeing to neighboring Bangladesh to seek asylum. After confiscating prior national registration cards, Myanmar began issuing temporary registration cards, white cards, to members of the Rohingya in 1995. These cards expressly denied citizenship and residence rights. The cards also introduced race and religion identification, branding the Rohingya as Bengali. In 2014, Myanmar launched another verification process. White cards were exchanged with national verification cards, which emphasize that they do not evidence citizenship and that cardholders are persons who, quote, need to apply for citizenship. Although the cards themselves did not identify race, authorities compelled applicants to forswear their Rohingya identity and register as Bengali to obtain the cards, thereby conditioning access to food, healthcare, fishing licenses, and other employment on rejection of their Rohingya identity. Myanmar also pursued policies aimed at suppressing Rohingya family formation and births, deliberate demographic engineering, cloaked in administrative language. A Mangdao Regional Order from February 2008 titled Regional Order and Processes for Controlling Bengali population justified control on, quote, extremely high population density, population increase beyond the international standards, and children who are not controlled and systematically taken care of by the parents, creating problems for the human environment. The order imposed a prior permission regime on all Islamic marriages, requiring review by various authorities and border police, as well as registration with the so-called Illegal Entry Prevention People's Group. While certain aspects of the order applied to Maung Dao's non-Muslim minority, particularly onerous conditions applied uniquely to Muslims. A dedicated annex listed additional requirements solely for, quote, Bengalis who apply for permission to marry, confirming the order's discriminatory focus on Rohingya. Even where permission was granted, couples were required to limit the number of children in order to control the birth rate. The order also restricted marriage timelines, banned under-18 marriages, and criminalized relations outside wedlock. The order specified various punishments for violations of its provisions, including up to 10 years imprisonment. The order expressly justified itself as being, quote, for the good of the region and the race. The race here is, of course, to the exclusion of the Rohingya. Myanmar also attacked legal identity at its source. It denied birth certificates to Rohingya newborns. Even Myanmar concedes that birth registration of Rohingya babies came almost to a halt after the violence of 2012. In fact, as reported by the UN fact-finding mission, the UN Special Rapporteur, and the UN High Commissioner for Human Rights, Myanmar stopped registering the Rohingya births in the 1990s. As the fact-finding mission observed, legal identity starts with a birth certificate. Denying the issuance of birth certificates to Rohingya newborns is a deliberate tool to erase the Rohingya. Finally, I turn to confinement, segregation, and deprivation. Mr. President, genocide can proceed by indirect methods of destruction. As scholars have noted in other contexts, confinement and systematic deprivation can cause death even before overt killing. In this regard, a former humanitarian worker who spent months in Rakhine State testified to the UN Independent Investigative Mechanism for Myanmar that beyond the large-scale acts of violence against the Rohingya that made the headlines, it was the, quote, everyday systematic human rights violations that added to an unbearable pressure of Rohingya daily lives. He said he considers Myanmar's conduct tantamount to genocide because the Rohingya just simply couldn't live. Every avenue of survival was closed down around them. Myanmar does not dispute that after the 2012 riots, the Rohingya in and around Sitwe, the capital of Rakhine, were segregated into camps distinct from those housing Rakhine communities, and that until today, 13 years on, 18 Rohingya camps remain, while those of all other ethnic groups have been closed. These are not ordinary IDP camps. Given the severe deprivation of liberty imposed on camp populations, some humanitarian actors and analysts have referred to the camps as internment camps. In these open-air prisons, approximately 126,000 Rohingya are being held indefinitely. Human Rights Watch reports that the Rohingya remain in these de facto detention camps surrounded by fences, police, and military. The International Crisis Group indicates that the Rohingya there are subject to apartheid-like bans on access to hospitals and schools. And a UNICEF spokesperson testifies to the dire sanitary conditions there. I quote, "The first thing you notice when you reach the camps is the stomach-churning stench. Part of the camps are literally cesspools. Shelters teeter on stilts above garbage and excrement. One camp manager reported 4 deaths among children ages 3 to 10 within the first 18 days of December 2018. Outside the camps, Rohingya have also been forced to live separately in the Aung Mingala ghetto in Sittwe. Contrary to Myanmar's assertions of freedom of movement there, independent parties such as Médecins Sans Frontières report that for over a decade, Rohingya have been confined to this small neighborhood, denied freedom to move, with police outposts guarding it day and night. The UN fact-finding mission also stressed that in Aung Mingala, the Rohingya are trapped and guarded by armed police, checkpoints, and barbed wire. When George Soros, founder of Open Society Institute, visited it in 2015, he reported as follows, I quote, "In Aung Mingala, I heard the echoes of my childhood. You see, in 1944, as a Jew in Budapest, I too was a Rohingya. Much like the Jewish ghetto set up by Nazis around Eastern Europe during World War II, Aung Mingala has become the involuntary home to thousands of families who once had access to healthcare, education, and employment. Now they are forced to remain segregated in a state of abject deprivation." The Rohingya who are not confined in camps or ghettos are subject to severe movement restrictions that confine them to their villages and surrounding areas. The UN fact-finding mission describes a layered system of written and unwritten rules enforced through village and township level curfews, permits, and numerous security checkpoints administered arbitrarily and conditioned on bribes. To travel between townships, Rohingya must obtain temporary Form 4 permits, departure certificates from their village administrators. The UN mission records that by August 2017, there were more than 160 checkpoints in northern Rakhine, where Rohingya were uniquely subjected to questioning, extortion, and intimidation, unlike ethnic Rakhine. The Rohingya in Rakhine State had long sustained themselves through fishing, farming, and trading, but since 2012, curfews have curtailed early morning and night fishing. Fishermen are required to pay checkpoint fees and surrender part of their catch, and those found on the quote-unquote wrong area risk ill treatment, arrest, and violence. The UN mission finds that Myanmar's movement restrictions and specific limitations on access to fishing grounds, agricultural lands, and forests impede access to food and livelihood. Myanmar's harm on humanitarian access exacerbate these harms. The UN mission documents that access to Mangdao, Butidang, and Ratadang were severely restricted after the 2012 violence, and again in mid-2017 prior to the August 2017 clearance operations. In one example, Myanmar chose to revoke the travel and activity permissions of all humanitarian agencies assisting the Rohingya in Rakhine State in 2017, simply because the World Food Programme had published a report about malnutrition in Rakhine, pointing out that virtually no Rohingya children under age 2 met minimum diet requirements. A former humanitarian worker of Action contre la Faim, who was operating in Rakhine State at that time, reflected that, quote, "It was a cruel irony that a report exposing malnutrition was used to sever the vital lifeline of humanitarian aid. I recall the ACF nutrition team leader, Laura, saying in no uncertain terms that this decision would have immediate consequences. Children would die because our aid was being cut off." Discriminatory movement controls also translate directly into barriers to healthcare. The UN mission reports that restrictions on access to medical facilities have been enforced strictly, even in emergencies, such as obstructed labor, infants needing oxygen, or heart attacks. It observes that through these movement restrictions, Myanmar has exposed Rohingya to, I quote, "unnecessary suffering, immediate and long-term health risks, and preventable deaths." Members of the court, Myanmar's policies targeting the Rohingya operated in tandem with an affirmative state program to alter the demography of northern Rakhine by inviting foreign Buddhists to settle in Rohingya majority areas. The UN Independent Investigation Mechanism for Myanmar has analyzed official documents and state media showing that from 2013 to 2018, authorities encouraged Buddhist communities from Bangladesh's Chittagong Hill tracts to immigrate and settle in Rakhine State. The government's own newspaper reported that, quote, 742 households and 3,433 family members who moved from Bangladesh are being accommodated in Natala model villages and subsidized with household commodities and food for a one-year period. Not only were Buddhists from Bangladesh invited to immigrate to Rohingya majority areas in Myanmar, government agencies incentivized their resettlement by providing housing, farmland, rations, and cash, and issuing immigration permits and travel authorizations enabling free movement. Legal capacities categorically withheld to the Rohingya born and living in Myanmar. Significantly, Myanmar also placed these Buddhist migrants on an expedited path to citizenship and granted them citizenship scrutiny cards. Myanmar's enactment of these policies, while denationalizing, suppressing births, segregating, confining, and depriving the Rohingya of access to food, healthcare, and livelihood, provides further evidence of its intent to diminish and erase the Rohingya in Rakhine State. As the UN fact-finding mission observed, considered alongside the criminal acts that followed, Myanmar's discriminatory policies support the inference that it deliberately imposed conditions of life calculated to bring about the Rohingya's destruction in whole or in part. In 1946, the Nuremberg Tribunal found that a series of discriminatory laws aimed at eliminating Jews from the German life and economy paved the way for the final solution. So too here, Myanmar's discriminatory policies paved the way for the genocidal clearance operations. Mr. President, members of the Court, this concludes my submissions. I thank you for your attention, and may I respectfully invite you to call Mr. Suleiman to the podium after the afternoon break.
I thank Ms. Pasipanodia for her statement. Before I give the floor to the next speaker, the Court will observe a break of 50 minutes. The sitting is suspended. Please be seated. The sitting is resumed. I now give the floor to Mr. Arsalan Sleman. You have the floor, sir.
Thank you, Mr. President, members of the court. Before the break, you heard about Myanmar's decades-long program of otherizing the Rohingya by denationalizing them and implementing policies to persecute them. I will now focus on related but distinct indicators of genocidal intent. Myanmar's campaign of hate speech and propaganda against the Rohingya, and the hateful utterances of Myanmar soldiers during the clearance operations. As I will discuss in detail, Myanmar's anti-Rohingya hate campaign served to dehumanize the Rohingya group and incite hatred and violence against them. At its core, this propaganda portrayed the Rohingya as subhuman and as an existential threat to the Buddhist majority population of Myanmar, such that violence against the Rohingya was not just acceptable, it was necessary. This hate campaign stretched over many years and was disseminated through various forms of media, including through speeches by the chief of Myanmar's military junta, Senior General Min Aung Hlaing. It included admitted fabrications about the Rohingya group, as well as the clandestine military use of Facebook accounts to spread hatred of the Rohingya. The anti-Rohingya propaganda served both to justify and incite the genocidal violence during the 2017 clearance operations. And the hateful utterances of Myanmar soldiers during the clearance operations confirm both the impact of that propaganda campaign and Myanmar's genocidal intent. I begin my presentation by showing, with the assistance of historical comparisons, that anti-Rohingya hate speech and propaganda are compelling indicators of genocidal intent. I will then focus on representative examples of anti-Rohingya hate speech and propaganda disseminated through various means, including openly by Myanmar officials, surreptitiously through Facebook accounts, collaboratively by and through extremist Buddhist monks, and finally by Myanmar soldiers during the clearance operations. The inescapable conclusion is that Myanmar acted with genocidal intent as it engaged in its brutal clearance operations against the Rohingya group. The UN fact-finding mission identified two indicators of genocidal intent related to what the Gambia refers to as hate speech or anti-Rohingya propaganda. Those are the insulting, derogatory, racist, and exclusionary utterances of Myanmar officials and others prior, during, and after the clearance operations, and the government's tolerance for public rhetoric of hatred and contempt for the Rohingya. The Gambia has addressed both of these indicators together because of their intertwined nature. There is ample support in case law regarding hate speech or anti-group propaganda serving as an indicator of genocidal intent. Some trial chambers of the International Criminal Tribunal for Rwanda, for example, cite the use of derogatory language towards members of the Tutsi group as an indicator of genocidal intent. And others also cite the specific utterances of perpetrators as an indicator of intent. the historical record of other genocides helps to vividly demonstrate hate speech or anti-group propaganda as an indicator of genocidal intent. Key themes of the hate speech and anti-group propaganda used in other such genocides are abundantly present in Myanmar's anti-Rohingya propaganda. I will focus on 3 of those themes: dehumanization, accusations in a mirror, and threats to group purity, as defined by the Dangerous Speech Project, a nonprofit group of experts focusing on speech that incites violence. The first theme is dehumanization, a critical element in the path to genocide. Hate speech or propaganda that dehumanizes the target group prepares a population to tolerate or engage in violence against that group. Dehumanizing rhetoric often compares the target group to animals, insects, or biological hazards. The point of such comparisons is to make the desired outcome of the speaker, destruction of the targeted group, the natural response to such a threat. In Rwanda, Hutu hate speech against the Tutsi group notoriously referred to them as inyenzis, or cockroaches, that required extermination. During the Cambodian genocide, the Khmer Rouge regime's enemies were called microbes, or a sickness that needed to be eliminated or removed. The Nazis carried out a long propaganda campaign against Jews, portraying them as vermin, subhuman, and an inferior race. As I will show later, various types of Myanmar's anti-Rohingya propaganda and hate speech dehumanized the Rohingya by using slurs like kalar and referring to them as dogs, carp, crows, maggots, ogres, fleas, and thorns that required elimination. The second theme is called accusations in a mirror. According to the Dangerous Speech Project, the most powerful way to foment intergroup conflict is to frame violence as the only way to protect an in-group against greater harm, even annihilation. To accomplish this, propagandists use a tactic called accusations in a mirror, in which they attribute to their enemies the very acts of violence that they plan to commit against the target group. The term accusations in a mirror originates from a propaganda manual found in Rwanda. Hutu propagandists like Leon Mugesera used this tactic to justify and foment violence against the Tutsis. In one example, Mugesera stated, "These people called inyenzis, cockroaches, are now on their way to attack us. They only want to exterminate us. They have no other aim." The Nazis employed the same tactics against the Jews. For example, a 1941 pamphlet authored by Joseph Goebbels asks, "Who should die, the Germans or the Jews? You know what your eternal enemy and opponent intends for you. There is only one instrument against his plans for annihilation." General Ratko Mladic, the butcher of Bosnia, who was found guilty of genocide for directing the killings at Srebrenica, had claimed that Muslims, quote, were planning for the complete annihilation of the Serbian people. The use of accusations in a mirror by these individuals in their respective historical contexts in Rwanda, Nazi Germany, and Bosnia exposes their genocidal intent. And as I will soon show, Myanmar, and Senior General Min Aung Hlaing in particular, unambiguously made very clear use of accusations in a mirror. they falsely accused the Rohingya of posing a genocidal threat to Myanmar's Buddhist majority population in order to justify the genocidal clearance operations against them and incite other ethnic groups, especially the Buddhists of Rakhine State, to join and support the slaughter. The last theme is threats to group purity. In such messaging, the hate speech or anti-group propaganda focuses on the threat that the targeted group poses to the purity of one's group. Nazi propaganda often focused on the threat to Aryan racial purity posed by Jews and other targeted groups accused of corrupting German society. Similarly, much of Myanmar's anti-Rohingya propaganda focuses on the threat posed by the Rohingya to the racial purity of Myanmar's so-called national races. All three of these propaganda themes, which featured decisively in past genocides, are central components of Myanmar's anti-Rohingya hate propaganda. This historical context affirms that hate speech and anti-group propaganda is a powerful indicator of Myanmar's genocidal intent against the Rohingya group. Mr. President, before I proceed to discuss the content of Myanmar's hate propaganda, I pause to address Myanmar's argument that much of what the Gambia calls hate speech is not actually hate speech. First, whether the content at issue meets a specific definition of hate speech is immaterial. What the court must determine is whether Myanmar's use of this messaging constitutes an indicator of genocidal intent, as argued by the Gambia and as supported by historical comparison and international jurisprudence. Second, Myanmar does not propose its own definition of hate speech, nor is there an established definition of it under international law. Both the UN fact-finding mission and the IIMM provided their own definition of the term for purposes of their respective reports. The fact-finding mission used the term to refer to any expression of violent or discriminatory hatred towards people. In its report entitled Anti-Rohingya Hate Speech on Facebook, the IIMM considered content as hate speech if, in its view, it, quote, was intended or likely to influence its audience to fear the target group, hate the target group, and or to encourage, support, or excuse discriminatory measures or violence directed against the target group. To the extent that a definition of hate speech is necessary or helpful, the Gambia considers the mechanisms most relevant. Myanmar also argues that hate speech is a global problem and not a challenge unique to Myanmar. That may be true, but most states have not engaged in years-long anti-group hate propaganda campaigns, including clandestine ones on social media. Nor do most states launch military attacks on civilians with its soldiers uttering hateful anti-group messages as they engage in brutal genocidal violence. In any event, whether similarly dangerous anti-group hate speech and propaganda exists in other countries is not the focus of this case. Mr. President, members of the court, I will now focus on representative examples of Myanmar's anti-Rohingya hate speech and propaganda as it has been disseminated by senior Myanmar officials and institutions. I begin at the top with the head of the military junta government, Senior General Min Aung Hlaing. In early September 2017, just days after the second wave of clearance operations commenced, in a widely disseminated speech, Senior General Lang said the following: Rakhine ethnics lost their land in the Alethankia crisis that broke out in Rakhine State in 1942, in which Bengalis attacked, murdered, and coerced them into leaving their homes. We will never let such a terrible occurrence happen again. During the Alethankia crisis in 1942, over 20,000 ethnic Rakhine people were slaughtered. Bengalis, after murdering ethnic Rakhine people, seized their lands and villages and lived there. The Bengali problem was a long-standing one, which has become an unfinished job, despite the efforts of previous governments to solve it. The government in office is taking great care in solving the problem. This is an example of accusations in a mirror, with a historical twist, where Senior General Lang is blaming the Rohingya for historical violence and using that to justify the government's violence against them to resolve the unfinished job. The UN fact-finding mission found that the Commander-in-Chief's explicit link between the 2017 clearance operations in Rakhine State and an unfinished Bengali problem dating back to 1942 reveals that the 2017 military operation was not only to respond to the ARSA attacks and to quell the threat posed by this group, as has been claimed. It rather speaks to a broader objective on the part of the Tatmadaw with historical roots and reinforces the narrative that all Bengali are a problem and that a distinction between terrorists and civilians or victims is not relevant. Later that same month, September 2017, while the clearance operations were still in progress, Senior General Lang, in another widely disseminated speech, said, quote, "The Bengali population exploded, and the aliens tried to seize the land of local ethnics. Race cannot be swallowed by the ground, but only by another race. All must be loyal to the state in serving their duties so that such cases will never happen again." End quote. Here again, Senior General Lang is deploying accusations in a mirror. He accuses the Rohingya of trying to seize Rakhine land. He invokes the Myanmar government's motto of racial paranoia, raising the threat that the Rohingya will swallow up the Rakhine race. And he demands loyalty to the state, which, he says, is carrying out its duties to make sure that such violence from the Rohingya does not happen again. There is a third example of Senior General Lang deploying accusations in a mirror, this time explicitly regarding genocide. In a public speech in December 2017, Senior General Lang said, quote, "During the latest terrorist attack in Rakhine State on 25 August 2017, villages of local national races were threatened, and many local national races people were murdered. Our Tatmadaw have to safeguard the national races forever and carry out for them to live in unity and peace. Tatmadaw must fully protect the ethnic minorities in Rakhine region, not to have the genocide." End quote. This was a clear message that the Rakhine must be protected from genocide by the Rohingya. This propaganda, blaming the Rohingya for potential genocide to justify violence against them, is as direct an expression of genocidal intent as that by Mugesera, Goebbels, and Mladic. There should be no doubt about Senior General Lang's genocidal intent against the Rohingya. Mr. President, the same intent vis-à-vis the Rohingya is evident in the Tatmadaw generally as well. Tatmadaw training materials from 2012 entitled Fear of Extinction of Race, propagates the narrative that the Rohingya pose a threat to Buddhist existence. It also uses dehumanizing slurs and invokes threats to Buddhist racial purity. It contains the following propaganda. The danger of being swallowed up by Bangladeshi Chittagonian kowtow collars truly exists. No race fears extinction from being swallowed up by the earth, but by human beings. Bengali Muslims infiltrate the people to propagate their religion. We need to protect our race and religion as much as possible. Otherwise, Buddhism may vanish. The UN fact-finding mission observed that through its training program, the Tatmadaw indoctrinates cadets with the concept that Islam constitutes an existential threat to Buddhism, such that the, quote, probability of population extinction truly exists. A book from the 1980s with the same title as the Tatmadaw training program, Fear of Extinction of the Race, had been distributed by the government. Like the training program, the book presents Islam as an existential threat to Buddhism. One passage states, quote, if we are not careful, it is certain that the whole country will be swallowed by the Muslim collars. When we study world history, we can see that different races of the world did not get swallowed to extinction by the earth, but only by other humans, end quote. Here again, the anti-Rohingya propaganda uses dehumanizing slurs and presents the Rohingya as an existential threat to Buddhist-majority Myanmar. It should perhaps come as no surprise that the Tatmadaw has a department called the Directorate of Public Relations and Psychological Warfare. This department, in July 2018, that is, after the main clearance operations, published a 117-page treatise called Myanmar Politics and the Tatmadaw, Part 1. This document blamed the Rohingya for instigating armed conflict against other ethnic groups in Myanmar based on fabricated evidence. A picture that the Tatmadaw captioned as Bengalis killed local ethnics brutally was actually an image from Bangladesh's 1971 independence war. In another fabrication, a long line of migrants is captioned, Bengalis intruded into the country after the British colonialists occupied the lower part of Myanmar. The image was actually of refugees who had fled Rwanda in 1996. And in yet another fabrication, an image of a boat full of people captioned as Bengalis entered Myanmar via the watercourse is actually an altered picture of Rohingya who were trying to escape Myanmar in 2015. Reuters exposed these fabrications, and Myanmar admitted to 2 of them. Other ministries of Myanmar's government also disseminated anti-Rohingya hate propaganda. For example, in 2018, Myanmar's Ministry of Foreign Affairs sent to several UN offices links to propaganda videos containing anti-Rohingya messaging, including accusations in a mirror. One such video by an anti-Rohingya activist claimed that Myanmar faces a, quote, threat posed by encroaching Islamic forces that wish to annihilate the ethnic Rakhine community and all other non-Muslims and destroy the deeply rooted indigenous Buddhist culture and even Buddhism itself, end quote. Myanmar's embassy in London disseminated similar materials in 2018. In a letter to a British parliamentary committee, the embassy listed an article which states in part, quote, the Bengali Muslims again and again attacked others, and they will again and again do the same if they are allowed to live there. Enough is enough. And the Bengali Muslims have now forfeited their right to live in the land of Rakhine State. End quote. Major political parties in Myanmar have called for genocide against the Rohingya with no legal repercussions. In 2012, when it held the majority in the Rakhine State legislature, the Rakhine Nationalities Development Party called for a final solution for the Rohingya in a printed publication. It said, quote, "Today, the union government and the citizens collectively need to have a decisive stand on the issue of Bengali Muslims. For our citizens, for the maintenance of Buddhism, for the protection of our culture, it is now time to sacrifice. Although Hitler and Eichmann were the greatest enemies of the Jews, they were probably heroes to the Germans. If inhumane acts are sometimes permitted to maintain a race, a country, and the sovereignty, our endeavors to maintain the Rakhine race and the sovereignty and longevity of the Union of Myanmar cannot be labeled as inhumane." End quote. The chair of another political party, the so-called Peace and Diversity Party, incited violence against the Rohingya in 2015 to an audience in Yangon. He said, quote, "I won't say much. I will make it short and direct. Number one, shoot and kill them. Number two, shoot and kill them. Number three, shoot and bury them. Number four, bury and shoot them. If we do not kill, shoot, and bury them, they will keep sneaking into our country. None of these incidents resulted in prosecution." State-controlled media also published content that dehumanized the Rohingya around the time of the clearance operations, calling them thorns that needed to be removed and blood-sucking fleas. Mr. President, members of the court, I now turn to Myanmar's clandestine anti-Rohingya hate propaganda campaign on Facebook, used to justify its genocidal violence and incite rank-and-file soldiers and other ethnic groups to attack the Rohingya brutally and indiscriminately. Myanmar denies that it engaged in such a clandestine program. As I will show, however, the evidence of Myanmar's covert program is overwhelming and indisputable. First, Facebook, which is now called Meta, conducted internal investigations using confidential methods and technology in late 2018 that uncovered this vast campaign. In an affidavit annexed to the Gambia's reply, Nathaniel Gleicher, head of security policy at Meta Platforms, testified that in August 2018, quote, 6 Facebook accounts, 6 pages, and 1 Instagram account were removed after the individuals or entities associated with those accounts and pages were categorically banned from Meta on human rights grounds. This included the official page for Junta Chief Senior General Min Aung Hlaing. Later that month, Meta removed an additional 12 accounts and 46 pages that it determined were linked to the Myanmar military and the original accounts taken down on human rights grounds. The evidence for that link was based on shared page administrators, shared digital cookies, and shared IP addresses associated with the Myanmar military from which the accounts were accessed. Meta determined that these accounts were engaging in something called coordinated inauthentic behavior, or CIB. By the end of 2018, in total, Meta took down 163 Facebook accounts, 485 pages, 17 groups, and 16 Instagram accounts, all found to be connected to the Myanmar military. Myanmar argues that these accounts were not removed on the basis of human rights concerns or hate speech. First, several accounts, including the official account of Senior General Min Aung Hlaing, were in fact taken down over human rights concerns. Second, Myanmar ignores the meaning of CIB. According to Mr. Gleischer's testimony, quote, Meta considers CIB to be coordinated efforts to manipulate public debate for a strategic goal where fake accounts are central to the operation, end quote. In other words, Meta determined that the Myanmar military was disguising its identity through these accounts to manipulate the public. Here, the goal of its manipulation was to spread anti-Rohingya hate propaganda. Meta's findings were confirmed by the independent investigative reporting by the New York Times in October 2018. Based on information obtained from former military officials, researchers, and civilian officials in Myanmar, the Times reported that hundreds of members of the Myanmar military were the prime operatives behind a systematic campaign on Facebook that stretched back half a decade and that targeted the country's mostly Muslim Rohingya minority group. A separate independent investigation by the IIMM confirmed that the accounts taken down by Meta formed an interconnected military network. The mechanism, which was given access to many of these accounts, including their public posts and metadata, found conclusively that these accounts, quote, formed part of a network on Facebook that was connected to the Myanmar military, end quote. Those links include overlapping administrators and creators, overlapping accounts posting to these pages, shared usernames and email addresses, the appearance of the abbreviation DSITD for the Defense Services Information Technology Department in email addresses used to register the accounts, and overlapping additional metadata like digital cookies and IP addresses connected with the Myanmar military. So how does Myanmar respond to this incontrovertible evidence? You can see on your screens now a passage from paragraph 1137 of Myanmar's rejoinder. Without providing any evidence or citations for its assertions, Myanmar admits that some, quote, government employees or members of the Tatmadaw or the police force created fake Facebook accounts. Then it suggests that a few of them, quote, may have used office internet connections to do so. Then it speculates, again without any evidence, that they might have done so outside the scope of their employment on their own initiative. And as usual, Myanmar concludes with another sweeping denial with no evidence whatsoever and an equal amount of credibility. Mr. President, members of the court, how likely is it that Myanmar security personnel would post tens of thousands of messages on Facebook through hundreds of accounts that they created with their military email addresses from military computers in military facilities consistently over many years on their own initiative without instruction or approval from the Myanmar military itself? That is unimaginable, especially for the Tatmadaw, known for its rigid hierarchy and control. Having established that Myanmar engaged in a several years-long anti-Rohingya hate propaganda campaign on Facebook, we can move on to the content of this campaign. As detailed in its report, the IIMM searched 43 of the removed pages for content between 1 July 2017 to 31 December 2017, before, during, and after the 2017 clearance operations. They found over 10,000 items that fell within its definition of hate speech. Over 4,000 of those items were unique. The rest were duplicates shared multiple times on different pages or on different dates. These messages reached millions of people. Based on its extensive review of this content, the mechanism identified the following 6 themes of Myanmar's anti-Rohingya hate propaganda. A. Denial of the Rohingya identity as a distinct ethnicity and/or as natives of Myanmar. Portrayal of the Rohingya as an existential threat to Myanmar. Portrayal of the Rohingya as a threat to racial purity of the recognized Myanmar ethnic people. Portrayal of Islam as a threat to Buddhist religious sanctity. Justification of violence against the Rohingya and/or denigration of the suffering of the Rohingya and portrayal of crimes against them as fabrications. These are, in large part, the same themes: dehumanization, accusations in a mirror, and threats to racial purity that Myanmar and the Tatmadaw have been propagating for many years, as I have already shown. I will now highlight a few representative examples of Myanmar's Facebook posts. On 24 August 2017, the day before the 2017 clearance operations, the Tatmadaw posted a message called Genocide of the Rakhine People, which was then reposted 3 more times over the next several weeks. This post invokes the 1942 incident that General Min Aung Hlaing also referenced, and states that the situation will be worse this time unless the state acts. Quote, May 13, 1942, the day of the Rakhine Genocide. In 1942 riot, only Rakhine people were murdered. If there were similar riots in the future, Rakhine might well disappear. This is because the Kalar are strong financially, well connected to the media and international organizations. Rakhine state will disappear if Myanmar and Rakhine are not united, or the state fails to adopt secure and strong policies. The Tatmadaw posted a similar message entitled Written with Rakhine Blood on 26 August 2017, the day after the 2017 clearance operations commenced. Once again, invoking the 1942 massacres, this post emphasizes unity to confront the Rohingya threat to Buddhist Myanmar. I won't read from the post, but the key language is on the slide on your screens. The Tatmadaw posted a message on 29 July 2017, and then again on 19 December 2017. That is, before and during the clearance operations, entitled, Why Did Hitler Kill the Jews? The post included pictures of Hitler and Nazis and read as follows, quote, In April 1939, horrifying massacre called the Danzig Massacres, or Bloody Sunday, broke out. More than 58,000 Germans were killed. Because of the massacre, Hitler quickly invaded Poland. The subsequent revenge of the Nazi Germans after their occupation of Poland against Polish Jews who had brutally massacred the German ethnics was reminded to this day lest the world forget. In his extraordinary and amazing speech, Hitler said to the Polish government directly, Danzig had been a German town. We were taking this town back today. The case of the brutal killing of 58,000 ethnic Germans in Poland just before the start of the war was swiftly and urgently dealt with. The perpetrators of such atrocities were only avenged, life for life, by the shootings of German sharpshooters. Why? Why would the Tatmadaw post this message before and during the clearance operations? This message excused and justified the Nazi invasion of Poland and the genocide of Jews that followed as avenging the false claim that Polish Jews had killed 58,000 ethnic Germans. The Tatmadaw is drawing a parallel here to justify its genocidal violence against the Rohingya. Its genocidal clearance operations are presented as revenge for the false claim that Rohingya had killed more than 20,000 ethnic Rakhine in 1942. On 27 August 2017, right after the 2017 clearance operations began, the Tatmadaw posted a message inciting violence entitled, "Let's Eat Dog Meat." It depicted a popular singer with a gun, used dehumanizing language, and incited violence against Rohingya dogs. Quote, "Today I heard that our Myanmar West Gate suffered a break-in that destroyed it. I'm ready to grab this thing called a gun. If one tries to behave like a dog, plot like a dog, then I don't hesitate to eat dog meat." On 28 August 2017, the Tatmadaw disseminated a video entitled "Soldier Rallying Ethnic Rakhine" on several Facebook pages. This video shows a Tatmadaw soldier using dehumanizing language, inciting ethnic Rakhine to genocide against the Rohingya, who are described as an existential threat. The soldier explains that the clearance operations will remove the Rohingya animals from their villages. Quote, "Our country, our state, our town, our village need our protection. Their population growth is large and increasing. They want to take over our ethnic minority population. We will clear the villages where those animals live. What we mean by clearing is that we know where the ethnic villages are located. We have marked the places. There will be a group blocking the Rohingya. There will be another group doing the clearing. The soldiers will be doing the clearing systematically. We will be moving around the area, clearing the villages of these animals. We have guns, we have bullets. That's what we came with ammunition and the spirit to attack these animals. We have come here. From small children to old people, if you can carry a sword, then carry a sword. If you can carry a stick, then carry a stick. Carry whatever you can and bravely face these animals. We need courage." End quote. The Tatmadaw shared a post on 2 Facebook pages on 6 September 2017 entitled 9/11 Myanmar and Cartoons, accompanied by 4 cartoons that depict Rohingya killing Rakhine, inciting Rakhine people to violence against Rohingya. Quote, "During the jihad attack of Muslims in Indonesia and Bangladesh, old people killed other old people. Women killed other women. Children killed children. Hundreds of thousands of Buddhist necks were slain by Muslims' blades. Now Myanmar, which is a Buddhist country, in order to prevent the same scenario that happened in Indonesia and Bangladesh, I want you to sharpen even the knives that you do not use at home. The ethnic Rakhine people who have faced the jihad will know best. End quote. In September 2017, during the clearance operations, and while the military was burning down Rohingya villages, the Tatmadaw disseminated several posts spreading the false claim that the Rohingya burned their own homes and villages. One post with a cartoon image of Nobel Peace Laureate Ms. Malala Yousafzai claims the Rohingya, quote, will also burn the entire Myanmar, end quote, to, quote, snatch away more land. In other posts, the Tatmadaw shared images purporting to show Rohingya setting fire to their own huts. This attempted fabrication was exposed by journalists like Jonathan Head, who testifies as an eyewitness that the Tatmadaw used members of the local Hindu community to pose as Muslim Rohingya in these propaganda images. His affidavit is at Annex 375 of the memorial. Several of the Tatmadaw posts in September 2017, during the clearance operations, sought to dehumanize the Rohingya, calling them maggots in the flesh and accusing them of breeding like rabbits. On 2 October 2017, the Tatmadaw posted a message entitled, quote, "You can get a 6-foot pit." The message was addressed to Kalars, a dehumanizing slur used against the Rohingya, threatening them with death. Quote, "Kalar so, like you, relatives of cows, we don't hesitate to punch you till your teeth fall out. You won't get a seat at the table, Marmoods. If you say you love the Myanmar land so much, you can get a 6-foot pit." The bracketed text that you see is text from the IIMM. A Tatmadaw post from 19 December 2017 entitled, "Myanmar will be a country of whores," was distributed on multiple pages. It praises past pogroms against Rohingya and calls for their exclusion. Quote, "Had General Aung Gyi and Ne Win not launched King Dragon Operation, Garuda Operation in Rakhine State, Buthadong, Mongdo, and Rathadong would definitely not have been on the map of Myanmar, but on the map of Bangladesh. If you continue to give them roles similarly, Myanmar would become a country of whores." Mr. President, all of these messages, which came directly from the Tatmadaw, demonstrate Myanmar's genocidal intent and incitement to genocide against the Rohingya. All of them fit the themes of dehumanization, accusations in a mirror, and threats to racial purity that are the hallmarks of past genocides. Indeed, the Tatmadaw openly invoked the Nazi genocide of Jews to justify its revenge for the false 1942 massacres of Rakhine, the, quote, unfinished job it was resolving. We also know that the propaganda was effective. In addition to the utterances of soldiers, which I will address later, comments on these posts were filled with calls for genocide. For example, in response to one Tatmadaw post on 24 August 2017, the day before the clearance operations, in which the military reported encountering so-called Bengali terrorists, over 200 comments used language like, "Kill all Kalar," "Shoot and kill all Kalar," "Don't leave any one of these Muslim dogs alive," "Kill all dogs, make them extinct." Myanmar says that the IIMM report is limited in duration. That is exactly right. from July to December 2017, and even then, the mechanism found over 10,000 items of hate speech. Imagine if the report covered a longer period of time. Myanmar says that only 1% or so of the posts are anti-Rohingya. Exactly right again. That is by design. The Tatmadaw was using fake accounts and inserting propaganda onto Facebook pages that normally would not post about such content in order to maximize impact. Mr. President, I conclude this section of my presentation with the mechanism's final assessment of its report. Quote, overall, the mechanism's analysis demonstrates that the Myanmar military spread material designed to instill fear and hatred of the Rohingya minority. It accomplished this by creating a clandestine network of pages on a social media site with the potential to reach an audience of millions. This campaign of hatred was ongoing at the very time that many Rohingya villages were burned, and while thousands of Rohingya men, women, and children were beaten, sexually assaulted, and/or killed, and continued as hundreds of thousands of Rohingya were forced to flee from their homes. The evidence from this analytical project conclusively shows that rather than taking all steps to prevent the violence and protect its people, the Myanmar military conducted a social media campaign that excused and promoted violence against the Rohingya minority. Mr. President, members of the court, Myanmar also spread anti-Rohingya hate propaganda by and through extremist Buddhist monks. They did this to leverage the respect that monks have in a country where almost 90% of the population is Buddhist. The military facilitated the rise of extremist monks who shared its intolerance for the Rohingya. According to a former monk, quote, military leaders approached our fellow monks with offers of financial support and gifts. This emboldened the monks to rise up and speak up in public to spread the pro-military propaganda, spreading hatred between religions, end quote. The main group of such monks was called Ma Ba Tha, or the Association for the Protection of Race and Religion. Ma Ba Tha published anti-Rohingya hate propaganda in official publications. In one article from June 2017, they used dehumanizing language, comparing the Rohingya to weeds that spread uncontrollably. And they warned that, quote, if the Myanmar government and the citizens are not careful, in a few years, Myanmar ethnic people, like the precious flowers, will be swallowed to extinction by the weed-like Bengali, end quote. Another Ma Ba Tha article from November 2016 was entitled, quote, the Myanmar race can go extinct due to the Bengali, end quote. The most prominent of the Ma Ba Tha monks is Ashin Wirathu. Senior General Min Aung Hlaing has donated directly to Wirathu, and photographs of the two together were widely circulated online in 2016. General Min Aung Hlaing awarded Wirathu in 2023 with the honorific Thiri Pyanchi title for his, quote, outstanding work for the good of the Union of Myanmar, end quote. Wirathu regularly uses dehumanizing language to refer to the Rohingya, calling them African carp, snakes, mad dogs, wolves, and jackals. The Tatmadaw disseminated Wirathu's anti-Rohingya propaganda on Facebook. For example, In a post by the Tatmadaw on 18 August 2017 entitled, quote, "Marry a Dog Instead of Marrying a Kalar," end quote, the post amplifies a dehumanizing message from Wirathu that Buddhist women would be better off marrying a dog rather than a Kalar due to the existential threat of Rohingya Muslims to Buddhism. The UN fact-finding mission reported that after the first wave of clearance operations in late 2016, the military facilitated Wirathu's travel throughout northern Rakhine State, where he visited villages that the Tatmadaw attacked and met with high-ranking military officers. According to the UN fact-finding mission, he returned to Rakhine State in July 2017 and visited 2 villages in Rathadong Township that were later subjected to clearance operations, Chutpien and Zaydipien. You will hear and see tomorrow the details of what happened in those villages. The Tatmadaw also shared the messaging of another monk, Sitagu Sayadaw, the highest-ranking monk in Myanmar. Sitagu delivered a highly publicized sermon in October 2017 during the clearance operations. He delivered his speech at a military training garrison. And in his speech, he provided absolution for genocide. Sitagu recounted the following parable, quote, "There were about 500,000 non-religious and evil soldiers who died in the war. Because of that, the king was not able to sleep at night, since in Buddhism, killing humans is one of the worst sins. The 8 monks who knew about this told the king, 'Don't worry, Your Highness, not a single one of those you killed was Buddhist. They didn't follow the Buddhist teachings, and therefore they did not know what was good or bad. Not knowing good or bad is the nature of animals. Out of over 500,000 you killed, only 1.5 were worth to be humans. Therefore, it is a small sin and does not deserve your worry.'" End quote. Not only was this sermon delivered in front of military troops during the clearance operations, but the Tatmadaw heavily disseminated it over Facebook, posting the sermon 11 times on its network of accounts. The message is clear. It is not a sin to kill Rohingya because they're not Buddhist. And because they are not Buddhist, they are like animals, not knowing what is good or bad. Mr. President, members of the court, I turn finally to the utterances of Myanmar's soldiers, which is both an indicator of genocidal intent and a means of confirming the impact on those soldiers of the propaganda campaign carried out at the highest levels of the Tatmadaw. The court has in its case file the sworn testimony of an IIMM legal officer who took the witness account of a Tatmadaw defector given the IIMM code P5513. That defector stated that the soldiers' quote, "opinion that Rohingya/Bengalis were not nationals of Myanmar was formed by the propaganda they were fed," end quote, and that, quote, "the accumulation of the open abuse by military officers towards Rohingya, together with the military's perception that Rohingya were illegal immigrants, led to soldiers believing they could do what they wanted with respect to the Rohingya," end quote. We can see from the following utterances of soldiers posted online during the clearance operations that they targeted the Rohingya as such for genocidal violence. Quote, if it's Kalar, get rid of the whole race. Kill all the Kalars that you see in Myanmar. None of them should be left alive. May the terrorist dog Kalars fall fast and die horrible deaths. These non-human Kalar dogs, the Bengalis, are killing and destroying our land, our water, our ethnic people. We need to destroy their race. Stuff pig's fat inside the damn Kalar's mouth. Pour fuel and set fire so that they can meet Allah faster. Cut off those necks of the sons of the dog and kick them into the water. Lieutenant Ki Nhan Lin of the 33rd Light Infantry Division, who participated in the clearance operations, posted on Facebook, if they're Bengali, they'll be killed. A police officer involved in the clearance operations posted on Facebook on 27 August 2017, have been wanting to kill these Kalars for so long, only got to kill them just now. A member of the 33rd Division told the Rohingya, the central government sent us specially to kill you Bengali people. A member of the 99th Light Infantry Division posted on Facebook, on the battlefield, whoever is quick will get to eat you, Muslim dogs. According to the UN fact-finding mission, Tatmadaw soldiers regularly told Rohingya that, quote, you don't belong here, quote, you are Bengali, quote, we will kill you all. Victims of sexual violence reported similar utterances. A Rohingya woman survivor who was gang raped recounted a member of the Tatmadaw saying, quote, we are going to kill you this way by raping. We are going to kill Rohingya. We will rape you. This is not your country. End quote. Another rape survivor from Mongdaw Township recalled her perpetrator calling her Kalar and saying, quote, we will rape you and kill you. Mr. President, members of the court, the Gambia submits that Myanmar's anti-Rohingya hate propaganda and the hateful utterances of Myanmar's soldiers during the clearance operations are conclusive indicators of genocidal intent, both of Myanmar's senior leadership and of its soldiers committing the acts of genocide. Thank you, Mr. President, members of the court, for your kind attention. This concludes the presentations of the Gambia for today. Mr. Lowenstein will begin our next session tomorrow with a presentation focusing on Myanmar's so-called clearance operations.
I thank Mr. Suleiman, whose statement brings this sitting to a close. The oral proceedings in the case will resume tomorrow, Tuesday, the 13th of January 2026 at 3 p.m., when the Gambia will continue its first round of oral argument. The sitting is closed.